And I think we're live, maybe. I hope.
Sometimes it takes a second.
It does.
Yeah.
Well, and always wait because the ads come up, you know.
There we go. I think we're live now. Not on mine. I don't have ads on my YouTube.
I don't either.
Hi, everybody. There we go.
Hello,
So
everyone.
here we are. It's not on mine. Finally. And I'm hearing some. Hi, everybody.
Somebody doesn't have their YouTube muted. Is it me?
Finally.
Oh, did I? No, I think I closed my YouTube. No, I didn't. Hold on.
It was me.
Okay.
Hello. Okay, I think we're good. Yay.
Sorry.
Welcome, everybody, to the first, is this the first 80 More Things live broadcast we've done? I guess it's technically the second because we did a test at one point, right?
Yes, we did.
So, but this is our first official live broadcast for 80 More Things. So welcome, everybody. Thank you for coming. Very happy that you came.
And, like the fifth time.
And I'm super happy to have Travis and Tracie, and obviously Julie. I'm always happy to have you here. So Julie and I are very happy to welcome Travis Williamson and Tracie Strunsee to talk about the appeal of Stephen Avery and the state's response.
Sorry. I'm so sorry. Okay.
So without further ado, I do want to say, if you have a question throughout the presentation, Travis and Julie have worked very hard on putting together a good presentation here. So we're going to let them go through that. And if you have a question as we're going along, go ahead and just type the word question in all caps, so I'll see it more easily. And we'll have a Q&A session at the end. So feel free to type your questions in as we go along, and we'll answer those at the end. Okay? Everybody good? Everybody ready?
Does anybody want to mention why we look like this?
Oh,
Yeah,
Oh, yeah.
That's how you did.
I totally forgot we were wearing costumes.
Well,
So we've just come from a Zoom costume party, and it was a lot of fun. So that's why we're half drunk and wearing costumes.
The three of you were at a party. I am not in a costume. Whether I'm half drunk or not, I'll leave up to people to decide as we go.
Hi, Mitch. Hi, Jane.
I'm going to have to remove this costume. I can't see anything.
Fen is queen of the universe. Tracie is a tourist.
I'm a tourist at Disney World.
And I am a social butterfly.
I just have a crown. I always wanted to wear a crown.
Beautiful crown
with those glasses on. So
queen of the universe. And
okay.
Travis is a half-drunk lawyer.
Is Tracie a rodent?
Yes, I'm a mouse.
She has mouse ears on. You've been using that, Travis.
I have Minnie Mouse t-shirt on, and I even have my magic band on. So I'm ready to go. Oh, and I have shoes. I have Disney shoes.
She has shoes.
So I'm all set.
The surprises on your channel are far superior than the surprises on Tracie's channel.
Yes.
So far.
Just saying.
I couldn't get my ears to come to work.
Okay. So without further ado.
Oh, God. I need to take this out of my head now. Sorry. Okay. Go ahead. I'm ready.
Let's get started. Take it away, Travis.
Okay.
First,
go to the next
first slide. Okay, so we're going to go through the original appellate brief of Kathleen, and we're going to incorporate the response brief the state filed this week, kind of go through them in parallel and together, and get everybody up to speed. This is pretty much from the legal side, so it's not going to contain all of the theories you're used to hearing about. It's focused what's going on in real time at the court, with the appeal at this period, as of today, actually. So first, we're going to get into the procedural history of the appeal. Kind of have to know that to understand some of the key issues that the states raised in response to Kathleen's brief. We're going to be discussing the key issues, how each party has approached it. And then at the end, we'll have question and answers. And like Fen said, if you type in question, all caps, and you just want to write it down and then put it later. And when we get the Q&A, be sure and get to your questions. Next slide. Wish I had one of those clicker things. Okay, so it's called the corrected brief because Kathleen inadvertently tried to e-file it a couple of days early, and then they called the court and said, oops, we're sorry, we know you're not supposed to e-file it first. We are sending a paper copy. And there were some problems with some signatures and whatnot. She got that all fixed and refiled the hard copy, and it's been relabeled corrected brief. It's identical to the first brief she filed, but when you go to the Wisconsin Court of Appeals site docket, you can download it online and it'll download the corrected brief. So that's the one we're using in terms of when we refer to page numbers, paragraphs, all of that. But that's why it says corrected at the top. There was a little issue with the filing. That happens all the time, and it doesn't affect your appeal at all in that regard. That was filed way back in October, everybody remembers, and then the state got a couple extensions by motion, and then, of course, the pandemic hit, and then the courts in Wisconsin, Texas, everywhere that I know of have pretty much been shut down from March until they're just starting to open up in Texas, and they gave automatic extensions. State filed theirs a couple of days early this week. It was due Friday. We expected to do this presentation Thursday night, but it got their response got filed Wednesday, 2 days early. So we just recombined it and decided to do it tonight. So she's requested oral argument on page 4 of her brief, Kathleen did, and the state says, and the reason she said it oral argument and that it should be published is because the case involves issues of first impression in the state of Wisconsin, for example, the evidence preservation statute. To our knowledge, there's been no case construing the evidence preservation statute, which is issue 10 in her brief. The state, on the other hand, says that these are run-of-the-mill black letter law issues of no import or significance, and therefore oral argument isn't necessary. As Tracie has said repeatedly in this court, the Court of Appeals, it's very, very rare for them to grant oral argument in a criminal case. And so if that's true to form, I looked up all the cases that have been decided since the first year. They were all submitted on the briefs, meaning no oral argument entertained in the Court of Appeals. So there's that. She burned up 32,241 words of her 35,000 limit. The state took it all the way to 34,800. They took it all the way to the wall. But when you read through that brief, they keep repeating, as we'll get into it, the same thing over and over and over again, procedurally barred, piecemeal, that's throughout their brief. So it's understandable why they needed more words. They had to keep repeating the same thing over and over again. She also refers, she filed a 4-volume appendix, and that's the appendix. You put all of the documents that you feel are pertinent into volumes and you number them. So it's easy for the Court of Appeals, when the briefs are sent, them to refer to the documents you're looking at rather than having to request the record, get it brought to their office. So it's 4 volumes, thousands of pages. And to my knowledge, nobody's requested. And so if anyone's eager to figure out a GoFundMe or whatever platform to raise money, I think we have all of the transcripts that are important and videos and that type of stuff. If anyone's of a mind, you should get that appendix. It would help in a lot of particulars. We can talk about that later. Next slide, please.
Hey, sorry.
And Tracie, interrupt at any time. Is that the right one where we're at?
Yeah.
So we're going to go through the procedural history and just highlight some dates that are important so y'all can understand the significance of the procedural issues that are being argued and counter-argued in the appeal. So as we know, an unfortunate date in 2007, March 18th, the day after St. Patrick's Day, Stephen was convicted by a jury and what we all feel to be wrongfully convicted for the second time in the state of Wisconsin. He, as the common practice there, and in Texas too, and every state I'm admitted to practice, you typically prefer to get other counsel to handle the appeal. And you do that in order to look at if trial counsel did anything wrong. Because if you're the appellate counsel for a trial you handled, it's really not likely to find that you did anything wrong. Sometimes you are. It's very, very rare. So what happened is from the state public defender's office, a couple of post-conviction lawyers were appointed to represent him post-conviction. Now remember that term, post-conviction, not appellate, post-conviction. So they looked at what they had and they filed a motion for new trial, which is a post-conviction motion that's filed in the circuit court. And they focused on a few issues. A lot of this has been in the MAM series about the juror being excused improperly, the one that had some family problems or somebody was in an accident or having a scuffle with his wife. You know, I don't know how that all came down, but I read all the appeals about it. There was the Denny issue they said was improperly decided. And then they also included a claim for ineffective assistance of counsel. That'd be Dean Strang and Jerry Buting, on the specific issue that they didn't handle the jury issue properly. They got an evidentiary hearing, and I hear all the time, and it's understandable, that Stephen has never gotten an evidentiary hearing in this case. Yes, he has. Judge Willis gave him an evidentiary hearing, and because it involved ineffective assistance of counsel, AC, who would have testified. That's right. Jerry and Dean both testified at an evidentiary hearing for Stephen. Next slide. Judge Willis in January of 2010 denies that motion. That then is affirmed by the appellate court in the Court of Appeals. In Wisconsin, like most states, to go to the Supreme Court, it's discretionary. That means you have to send what we call a petition for discretionary review in Texas, PDR, a petition for review in Wisconsin, and basically tell the court, this involves important issues. This is either why the Court of Appeals got it wrong, or this is why there's a split among the Court of Appeals, but this is an important issue and why you need to hear the case. And the court can either say, yeah, we'll hear it, or they'll say no. And that's what happened in Stephen's case. They denied the petition for review in December of 2011. And so for all intents and purposes, his direct appeal was over. So before we go to the next slide, January 25th, 2010, the motion for new trial was denied by Judge Willis. That is, those two attorneys up to that point in time were acting as post-conviction attorneys. When they filed their briefs in the appellate court, they started acting as appellate counsel. That's going to be important later. Okay, next slide. So then Stephen didn't have attorneys anymore. They fulfilled their obligations, and he's sitting around languishing. And as many prisoners in his position are wont to do, he filed his own habeas corpus post-conviction. In Wisconsin, it's called the 974-06 motion. Pro se means he filed it without counsel on his own. Valentine's Day 2013. So he brings several issues, and we won't go through all of these, but it's important. That last one. Additionally, Mr. Avery claimed the trial judge was biased, and both trial and appellate counsel failed to raise the issue of state, commenting on Mr. Avery's silence in the closing argument. That wasn't an issue. This is straight from Kathleen's brief on the procedural history, by the way. So if you want to go back and look at this, that's the section you'd look at. Number 7, she makes a big point of bringing up the fact that one of his issues was appellate counsel failed to argue retroactive disjoinder, which what she's telling the court is that Stephen had no idea what he was doing, which isn't all that unusual for prisoners who do their own post-conviction petitions. Let's see, next slide.
Before I go to the next slide, Travis, retroactive misjoinder. What does that mean? Is that what you were just saying, that he had no idea what he was doing?
Well, joinder is either parties or claims. Joinder is more in civil court, where somebody files a motion to dismiss because you failed to join an indispensable party. So, you know, that would be like in a probate case and you failed to name the executor. There's a million different examples, but in the criminal side of things, there's really not misjoinder, and there's not any retroactive misjoinder. The only question is whether you're tried with co-defendants or not. And Brendan had a constitutional right to have a separate trial from Stephen because Stephen was a convicted felon. That's procedural due process that you don't want to be in a situation where you might get convicted by guilt by association. So that's one of the things they look at. So it's joinder of parties. Defendants really don't care if they join all the claims. If they forgot, for example, to join the felon in possession of a firearm, he wouldn't care about that. He would say that's part of the same transaction or occurrence, or part of the same criminal pattern, part of the same criminal episode, and therefore they're barred by double jeopardy. There's other defenses, but it's nothing. I don't, there's some guy in the prison law library, a writ writer is what we call him, that has some experience, and that's who Stephen would have got hooked up with. And then they also have photocopies of other motions. Unfortunately, they probably never hang on to the ones that are successful. They just keep reprinting the ones that get denied all the time. Although suppression of evidence obtained by invalid search warrants, that was brought pre-trial. That's a non-issue. Now, he did bring an issue that wasn't raised before about the setup the sheriff had with him with counsel, and then I think someone found out after the fact that the deputies may have been overhearing the jailers, his conversation with counsel. Jerry Buting writes about that in his book and is really upset about it. So Stephen raises that, but for the most part, not a really good job of post-conviction appellate work here, which Kathleen covers in her brief.
Should I go to the next one now?
Yes, please.
Okay.
So, big surprise. The circuit court judge denies all of his claims, and Stephen timely appealed. This is very, very significant. As we'll see in a minute, go back.
Sorry.
That's okay. As we'll see in a minute, there's some overlap here. So we're now at the end of 2015. In January of 2016, we'll see KZ comes in on the case. I guess November of 2015 was Ma'am 1. Is that right?
December
of 2015, yes.
Yeah.
She sees it and comes in on the case. So what'll end up happening is that a motion to stay the appeal will be granted so that Kathleen can do some other things we'll talk about in a minute. Ultimately, decision is made in June of 2017 to file a motion to dismiss Stephen's first 97406 motion. And then in July, the appellate court grants that motion to dismiss. Let's go to the next slide and we'll see where the overlap is. Okay, this is what Kathleen in her brief phrases the motion for scientific testing. I think I use the term second post-conviction motion. So in January, she comes on board. August, 8 months later, she files that huge monstrosity of a motion in August of 2016. There's some stuff that happens after she files that motion. There's some letters you have to dig for, but they're on StephenAveryCase.org. Talks about letters, and you can pull those up. But basically, they send a letter to the judge and say, "Hey, yeah, are you proceeding, in the appellate court with your appeal case, or, it's up in the appellate court. Circuit court can't do anything. They don't have the record. What are you doing?" So September, she files motion to stay with the appellate court, where Stephen's pro se 974.06 motion was pending. And then she works out a stipulated order for scientific testing with the state that they get the judge to sign. This order will become significant later issues on the appeal that we're talking about now. And that's where they are able to test FL, determine that there's no bone fragments in it, red sticks of paint. They're also able to get 10 or 12 of the swabs, and they split those with the state. They get their swabs, and then some sort of a determination is made that they're too degraded to do the type of testing that Kathleen anticipated in her August motion, which was dating and doing some different things on the blood. Next slide. June of 2017, so a year later, she files the second motion for post-conviction relief, MPR, under 97406 in the circuit court. Again, there was some letters saying, well, wait, you can't file that now. You've got one pending. You can't have two going at the same time. Based on those letters, it appears he files a motion to dismiss the first 97406 motion, again, up in the Court of Appeals, again, written and filed by Stephen with no help from an attorney. The court grants, the appellate court, Court of Appeals, grants that motion to dismiss. And then now here's something that's very, very significant. I haven't seen either person, either side comment about in their brief. Maybe Kathleen will discuss it in their response. What we're going to see in a minute, what's happening now is the state is saying, by virtue of Avery requesting the Court of Appeals dismiss that first motion, that is a procedural bar to everything. He's done, he's out of court, it's over for him. But yet, the state, with three attorneys, the judge, and Kathleen and her team are working together to accomplish testing, to stipulate to testing, to do a number of things for months. And so I just think it's interesting, you know, that they suggest and get the Court of Appeals to dismiss the appeal on the first motion, so that the second motion, which was written by a lawyer, which was even if they didn't agree, the state with all the issues, was, you know, identified viable issues, which, you know, you always want as the other side. You want realistic issues as opposed to trying to prove and look up retroactive misjoinder. But, you know, they're familiar with all the cases on post-conviction relief and IAC and Brady. You know, probably nobody's up on the law on retroactive misjoinder. But anyway, so October, they grant the motion to dismiss in July. In the circuit court, unbeknownst to anybody, unannounced, issues an opinion on October 3rd. This was covered in MAM 2 a lot. And the judge denies the second motion on two grounds. One is that it was procedurally barred because he dismissed the first motion. And then the other ground was that on its face, her claims didn't rise to the level that would require a evidentiary hearing. So, for example, she would talk about an experiment on the DNA from the hood latch. And she, you know, when she ventures into logic, she kind of gets in trouble, the judge. She said, well, you know, 15 people swapped there's a finger on the latch, and 10 of them, no DNA was detectable, but 5 did have DNA. So, that means it's not, more likely than not, it's not substantial. Can't take anything from that. Of course, she failed to understand the second part of that, which was that the amounts left behind were hugely different. And so,
Where did Tracie go?
What's that?
Tracie disappeared.
I'm
Oh,
here.
there she is.
Sorry.
Hi.
Sorry.
Sorry. I'm sorry,
I
Travis.
got disconnected really quick. Sorry.
Okay. All right. I wonder where Justice is. Anyway, so so there, was a bit of panic. They called up the state and they said, "Hey, did you know this thing was coming down?" No. And well, we're going to file a motion that says, we had a meeting, we have an agreement for more testing. Will you join us in the motion? We said, no, we can't do that, but we won't oppose it. Well, the reason why they didn't want to agree to it is why we're in court right now. So she filed a bunch more information and tried to get the judge to reconsider that, and that did not occur. Then part of that was she found out that Detective Veely had a summary of the computer and photographs and web searches that would have been significant to trial counsel on impeaching Bobby. And so that was a Brady claim. She tried to get the judge to look at that. Judge refused. She went up to the Court of Appeals and asked them to remand, which they did. And that was in September of 2018. Then had the bone stuff start to appear in December of 2018. And she asked for another remand, which the court granted, to have the court conduct proceedings and hear testimony as necessary in order to rule on the motion. She denied it without conducting any proceedings. And so she now appeals. And she filed her brief and the states filed their brief. And so let's dig into it now.
Woohoo.
Next slide. There we go. Okay, so these are the significant issues for me. And they're all kind of interrelated, but the main thrust of her motion, and you always try as an appellate lawyer to start with your strongest issue first, and then end with a strong issue, your second or third strongest maybe. And that's what I think she did in this case. She started with that the judge abused her discretion in not vacating the motion in light of the parties reaching an agreement on more testing, the parties reaching agreement that certain issues would be abandoned and certain new issues would be added. She didn't elaborate or brief what the new issue would be. Logic tells us the issues she agreed to abandon would be the brain fingerprinting and the prosecutorial misconduct about the inconsistent arguments in Brendan's and Stephen's case. Stephen, the only one responsible. Brendan's case, was he there? Did he help? Completely inconsistent. And her expert out of Pace University is same expert that Tracie's guest. I'm terrible with names, Tracie, the lady from New York. Her son's
Doreen Giuliano.
Yeah, Doreen,
John Juca case, yes.
her attorney has the same expert, but he abandoned that because it's just not really strong in Wisconsin. So we got, he's saying it was wrong for her to not take all of that in consideration and vacate the order. Her next argument is Brady claim, 5+1, the 5 original Brady claims she had in her motion, plus the one she added on the computer and the VLE summary, and then ineffective assistance of counsel. And then she's also finished up with the preservation of evidence, the young blood. Next slide. So what he's saying is they court abused its discretion when the parties had worked out a deal. This goes in, she doesn't specifically say, we worked on this case together cooperatively, 10 months after the appeal was dismissed, and this was never raised. Now, keep in mind, she filed the motion for post-conviction relief herself in the summer. The judge issued on her own, without getting any additional briefs from anybody, she issued that order. And so nobody was arguing this or anything, but she issues this October 3rd, 2017. And nobody's asking her to, she's not asking for status. She's, nothing, just out of the blue, but yet she knows that they were working on these things. She was never updated about the status of the testing, except to the extent that the evidence that was deposited with the clerk, they had to check out from the clerk. The evidence that was on deposit with the sheriff's office, they checked out from the SO, and from the lab, they checked out from the lab. So the judge may have been aware that trial evidence was checked out, and the receipts are in the documents that anybody can look at. It was checked out, and then it was returned to the clerk. That's all she'd know is, there's no doubt, I think a lot of people would have been surprised by that. And, it's just one of those unfortunate things that happen in litigation. But, she points it all out in her brief, and you can look in the argument sections. For example, prosecutors agreed would be allowed to conduct testing on license plates. This is in addition to all the other stuff. This is a whole new category of stuff. Conduct DNA testing on the lug wrench, microscopic examination of the pelvic bones. So we're going to get Eisenberg plus her expert at the same time to do a microscopic examination of the bones, which Kathleen's expert says is below the standard of care at the time of the trial for a forensic anthropologist not to do a microscopic examination, because Eisenberg makes no mention of it. They were going to give her access to the RAV, which she starts with. The RAV4, which is lab item A, would be made available to experts Reich and Palahniuk for a complete examination of the interior and exterior of the RAV for additional testing. They had all of that worked out. Next slide. Before that order was prepared, she issues her order. Been over that. Goes through what I just mentioned during the last slide. That she calls the prosecutors and can't get them to join in the motion, but they agree not to oppose it. She then files her 3 days later. The order comes out October 3rd. 3 days later, October 6th, she files a motion to vacate. So she didn't sit around to try and fix this error. She moved on it immediately. When the circuit court did not timely respond to current post-conviction counsel's October 6th motion to vacate, current counsel filed a motion for reconsideration October 23rd. That's a reference to the record and the appendix there. And so get those appendices someday, that'd be cool. The motion to reconsider, she filed several pleadings. All of those were denied in one motion, November 28th. She denied all of them in a very, very short opinion order that really didn't get into the merits much at all. It was really kind of snipey, snarly. I felt inappropriate in some respects, but she was, you know, well, if you were going to do this, then you should have done, you know.
Snippy.
Yeah, very. What did you think, Tracie? I think you and I've talked about this in the past, that was kind of what started the, you know, the crossfire between those two.
Well, I mean, obviously, I thought that there was a lot of digs taken at each side. You know, even in this brief, they try to make it sound like Kathleen is a first-year law student who doesn't know what the hell she's talking about because she makes no substantive arguments and nothing of any substance whatsoever, and insufficiently pleads everything. And then Kathleen is just a snarky back to the state about some of the things they've done. And so, yeah, it's definitely been it's been almost like a playground fight in addition to a courtroom battle.
Right. And then
No, you're a meanie poo-poo head.
What?
Yeah.
I said, no, you're a meanie poo-poo head.
Yeah, exactly. That's exactly what we're talking about. It's like we're gonna stomp
Yeah.
our feet and yell the loudest, and that's how we're gonna win. And that's why I put in the chat before, I said that the state's argument is I'm right, you're wrong, I win.
right. Yeah.
That is the extent of their argument.
Yeah. I can't see chat, by the way, so I'm not ignoring anybody. Hello, everybody. Glad you're here. Be able to see y'all when we're done and we do questions.
Say hi and bye to Justice, because I'm going to put her down now.
Bye,
so.
Justice.
Bye, Justice.
Bye, Justice.
Yeah. I'm going to put you
If you've
down.
just joined us, if you have questions throughout the presentation, feel free to please type them in chat, but put the word question in front of it so I can see it. And we will get to Q&A at the end. And welcome,
Linda, I
everybody.
took off
Thanks
my
for coming.
wings, But I was a social butterfly. See, these are my
Right.
antenna.
Costume party. I'm queen of, what did you say? Queen of the universe.
Queen of the universe. Fen is queen of the universe.
That'll work.
Many. I think it's inappropriate for you to touch your tip of your antennae on TV.
On television.
Live streaming.
Something about that.
It's okay. This
Are you
channel is not
offended?
safe for work. Okay, moving
Okay,
on.
next slide.
What's next?
Oh, sorry. Next slide.
Okay, so on this first issue about it was wrong for her the judge not to vacate her order based on the background. In both briefs, both sides for each issue set out a standard of review. So I thought we'd just go spend 30 seconds about what a standard of review is. So just about every issue imaginable that goes up on appeal, there's a standard. Once in a blue moon, there's not a standard, and like, did you count a Chad in an election or not? But other than that, because of this body of appellate law, they've formulated what the standard of review is. And basically, it's kind of like a burden of proof. But it tells, you know, what the appellate court can and cannot do. And so there's a lot of different ones.
I'm going to interject 1 second because this is exactly what we were talking about, because they say here that Avery contends that there has been a clear abuse of discretion. And the state makes a point of saying in one of their footnotes that that hasn't been something that we've used in like 20 years. It's like now it's an erroneous error of discretion. It's not abuse of discretion. That's how childish that this has gotten.
Yeah.
They have to put a footnote saying like, oh, you're so dumb. We haven't used that in forever.
Yeah, this sniping thing.
Right.
So, yeah, I guess judges didn't like, it's still abuse of discretion in Texas and pretty much everywhere else, but the judges were like, abuse, people are thinking I'm an abuser. And well, maybe if we came up with, erroneous exercise, they mean the exact same thing. She cited a case from a few years before, but yeah, I put that in there just as an example of the sniping.
Right. They just don't want to call it abuse. They don't want to use the word abuse because that is such a negative connotation, and that suggests misconduct. So they don't want to say that they abused their power, that it was just, an erroneous, they just made an error.
Right.
That's the way they want to look at it. Like it was just a harmless error. It wasn't that they abused their power in any way.
And so I don't really like erroneous exercise of discretion because it can be based on not doing something, which is not an exercise. It's a lack of exercise. So, I don't know. But in any event, you do want to try and use the buzzwords in the court you're in. But, I think it was a jab at them that they're from, the Chicago, Illinois area, maybe.
And that legitimately has been an issue. That has been an issue before. Kathleen has filed things under the wrong statute and used the wrong terminology based on Wisconsin law. So they're taking advantage of that, which has, again, nothing to do with the actual claims involved. That's just them trying to take a jab at his attorney. Like, you're not as smart as you think you are, or don't come into our state and act like you know the law better than we do.
Right.
And unfortunately, there have been things that are just, like I said, from state to state, it's different, and they've kind of used that to their advantage. But again, that's just a smokescreen.
Right.
Nothing.
Yeah, a big smoke screen. So people don't freak out about that one. It's, it's in a footnote, which tells the court, it's not a huge thing, but, we want to show the court that we're from Wisconsin and we know the right terminology, and it's really not that significant.
And they did that. They did that very early on when she first filed the petition. She also filed it as I believe an 81515 or an 80515. That was mistrial or in the interest of justice claim.
Right.
And 80515. And the same thing, the state responded with this really snarky response, like, well, we actually do have a statute, because Kathleen used this like really obscure case law to support her argument. And they were like, well, we actually do have a statute that makes that argument for you. But essentially, like, since counsel isn't aware that we actually have a statute that does that, she didn't need to cite this obscure case law to make her argument.
Right. They got off in the tall weeds. And that happened to me too. I started researching it. I'm going, oh, okay, well, no, this is good. And then I think it was you, Tracie, that told me about this case that says, no, that's only for civil cases. It doesn't apply to criminal cases.
Right. And that's Henley, State versus Henley. Yeah.
Yeah. And, maybe we'll talk about that, but which worrisome. But then Kathleen does point out that she was required to file a motion to vacate, which she did. That's a procedural step. That's a procedural bar. If you don't ask the court if you don't go to the judge, say, Judge, we think you made a mistake. We'd like you to fix it. If you don't give the judge a chance to fix their own mistake, they won't let you appeal it. Well, she did that. Okay, next slide. Then she gets into this argument, and we're not going to get in a bunch of detail about this, is that order I was telling you all about earlier, after she filed she got the appellate court to stay Stevens' handwritten self-prepared motion. She filed her motion for scientific testing, and she filed her second motion for 97406. It would have been her first, Stephen's second, but they all count against Stephen, his second. And the order comes out of the blue, and in this brief, one of our arguments is that the joint order for scientific testing kind of set out a little bit of procedure, and that by granting the motion and then not vacating it, she's going against that order. I don't know how strong a argument that is. If it's the court's order, the court can change its orders and amend them, and then this is when things started getting snipey. Is she filed a motion to recuse the judge as biased, and
Right.
it kind of went downhill from there. But that's, you have to do what you have to do. I'm not criticizing any of that. You have to put your client first, and if it's you're just not getting anywhere, you got to do what you got to do. But anyway, the state's response to this argument is, you get off into these issues about it actually goes back even to the order that they got entered during the trial, where Buting said, well, we want this stuff preserved, and Gahn said, well, we got an evidence preservation statute. I helped write it. Yeah, we can do that. And basically, this was the intent of the parties, is to, when sufficient testing came around, we would all come back and take a look at it. Next slide. Part B is a stretch. That's where I'm at. Did you have different thoughts on that, Tracie, or have you even had a chance to get into that much depth on it yet? About this is her argument that the agreed order stipulation for testing FL and the blood swabs should prevent the judge from dismissing the 97406 motion without any hearings or briefing.
Well, I mean, the 97407 is there for a reason. And once again, as the state has done many times, they act like that's there just for the heck of it. They're not treating it like a true procedural mechanism to actually move forward with this post-conviction process. So, yeah, it's the same thing as they've always done. They're trying to stand on procedure and say, like, well, just because it said that you could do this doesn't mean that that it makes a difference, I guess. Right? I mean, does that make sense? It's just saying that, like, just because you can do it, that's what the state's biggest argument is to everything. It's like, just because, there's a statute that says that allows it, they're trying to say that doesn't mean that it's actually allowable, which doesn't make a lot of sense. It's a lot of double talk. And the law is hard enough to understand without statutes being very circular in their referencing, which they are.
Well, yeah, this goes back to
They're like toddlers.
Yeah, they're like toddlers. It is.
Sorry,
that's how ridiculous it's gotten. Yeah.
Yeah, it goes back, the motion for rapid DNA testing, which the Court of Appeals denied, but they came up with, well, if you want to dismiss your appeal and then go forward under 97407, you can do that. And then that worked. The court did not remand, but then the thing with the ledger sheets, the last 2 pages of CASO, bones being returned, this would be a violation of the evidence preservation statute and probably Youngblood and its progeny. And they came up with the same response. Well, if you want to dismiss your appeal and file a, kind of, circular King's X type of stuff that, hey, you can't proceed unless you dismiss your appeal, Stephen's appeal. You can't proceed forward. So she dismisses. They get together and work together cooperatively for 10 months. The judge on her own throws it out for splitting the cause of action, filing a second 974-06, and not having grounds. Didn't even ask her, well, do you have good reason why these weren't brought up in Stephen's motion?
And that was probably the single biggest example of the state just being jerks, because they can be jerks within the law.
Right.
Was when they said that, well, you can always just dismiss this and we can try again. It's like, could you be more of a condescending ass? That was what they were saying right there, because clearly she can't just dismiss it. She puts in there that she says that if I don't bring this up now, I'm going to be subjected to procedural bar in the future, and then it's going to be a problem. And they know that, and yet they're still saying, well, you could just dismiss it and try it again later. And if it's procedurally barred, because that's what they're counting on. And that was probably the biggest instance of the state really just being that. Showing that they have no interest in justice or the truth. They said the truth function of the justice system.
Yeah. So, and the judge responded in that, return of bones motion that, that's a disingenuous offer to say dismiss and do
right.
this.
The judge called them out on that. That's why I have liked the Court of Appeals rulings better, because I think they've been very fair. And then they haven't been afraid to call them out and say, like, that's ridiculous that you even said that.
Yeah. So on this B issue, what the state's response has been that he's never raised this in any of her pleadings prior, and that Wisconsin law is that, she raised it in an affidavit, her affidavit in support of the motion to vacate, but it needs to be in the pleadings. And it's a footnote site saying in an affidavit is not good enough. You need to spell it out in her pleadings, but that's their main response on that.
Yeah, because the affidavit is good enough as long as you mention the affidavit. As long as you're adding as an exhibit, and as long as you refer to the affidavit, that should be enough. You don't have to repeat everything that's already in the affidavit. That's supposed to be the I know it's hard to believe, but the condensing function of not having to spell everything out in a brief is that I'm adding this affidavit for further information, but this is what they're saying. And I believe, she did enough, I think, for that, didn't she? I thought so.
I haven't looked at it specifically because it's such an ancillary issue about, I think she had much stronger arguments on why the judge should have granted the motion to vacate, beyond that the order, the way she phrased the issue under this capital B part was that by dismissing her motion, she violated her own earlier order. And the way the state handled that in their brief, one is they said, well, you didn't really ever specifically mention this prior to your appeal, it's in an affidavit, but I think it was an afterthought. So it's way down on my priorities of things to look at in more depth, but I haven't had a chance to look at it to see what she said about it. Plus the fact that there's 7 There's the motion to vacate followed by 4 motions for reconsideration and 3 motions to supplement. So it's a lot of digging.
It
Next
is. I mean, there's no arguing that it was a very bizarre way to file a complete petition, to do it like this, like as they say, piecemeal. It's very unusual, but the statutes allow for it.
And whose fault was it that she had to file it that way?
What,
Whose
Julie?
fault was it? It was their fault.
Yeah.
Because they were hiding stuff and she was finding it out
right
in pieces. That's why she had to do it that way. So they're the ones who caused it. And now they're going to criticize her for having to do it that way when it was their fault in the first place.
And again, I mean, the most obvious case of showing why it's okay is when the Court of Appeals actually approved, her to go back to the circuit court and include this in her petition so it could be added to the petition, whether it was the CD issue or the Bones issue. I mean, the Court of Appeals, the court they're in front of right now, is the one that okayed it and said, like, we would rather have you, we're not going to approve this because you can't add it at this stage, but we want you to go back to the circuit court and we want you to present it there and get a decision, and then it can be added to this appeal. And the state is, and that is the correct procedural mechanism. If it wasn't, the Court of Appeals would not have approved it. And yet now the state is saying that shouldn't be allowed, even though the statute allows for it. And essentially the state is, what they're saying is that it shouldn't be allowed because we don't want it to be allowed. That's essentially what they're saying.
Yeah,
sorry, but you're not the boss of the state.
Yeah, you're not the boss of me.
You're not the boss of the court.
Kathleen should just file that says, you're not the boss of me.
Yeah, you're not the boss of me.
That's exactly how it is. They are acting like they are the judge. And you're now second guessing the Court of Appeals. You are now saying that the court, I mean, essentially what you're saying is you're telling the Court of Appeals that they shouldn't have allowed it to be remanded to allow a supplemental motion.
Yeah, the Court of Appeals.
You shouldn't be able to allow to present it piecemeal. Well, that's exactly what they allowed. So you have to look at it and say, like, well, you're really, basically telling the Court of Appeals that they're wrong for how they handled it, which isn't the smartest way to do it. But when you know that they don't really have any stronger arguments, this is what they're grabbing at. They are avoiding dealing with the merits of this brief, of Kathleen's brief, completely.
Yeah.
And that's how they're going to do it. They're going to say, well, it shouldn't be allowed. Well, there's a statute that allows for supplements. And there's nothing that says when it can be allowed and when it can't. And when you have the Court of Appeals, the person that, or the court that you're actually presenting in front of is saying, no, we're not going to allow this here because it needs to be presented in the circuit court first, and it can be added to your petition. They gave them permission, and yet the state's still complaining about it.
Yeah, that's right. Next slide. Yeah, we're going to get to supplements here in a second.
Yeah, I probably jumped ahead. Sorry.
That's okay. No.
I'll be right back. Sorry.
Okay, so when we prepared this, it was going to, again, air Thursday with the state's brief coming out Friday. And what I originally prepared, and Julie and Fen can verify this, I was just putting down what I anticipated they were going to do, and I haven't changed it. And so I put, if they take a position, they didn't oppose the motion to vacate, they just wouldn't agree to it, it will track the circuit court order, which is exactly what they've done. They've tracked the circuit court order saying he had a pending pro se appeal, motion on appeal, that it was stayed, he dismissed it. And there's one I didn't catch, I put in brackets at the bottom, is failure to follow the court's order. State also raised that it was not brought up in the motion to vacate. It was raised on the first time on appeal, and in an affidavit, it's insufficient. So it's not like I'm clairvoyant or anything. As we'll see in a minute, Kathleen was anticipating problems with this procedural bar argument from the get-go. Next slide. Oh, you can't do it.
Well, since Julie and Tracie aren't here, so let's ask one of the questions. Let's
Okay,
go
cool.
back to the top. Nan's Life asked, how can a judge rule on a motion pertaining to a trial the same judge sat on?
That's just the way we do it in the United States, pretty much everywhere that they require certain motions be brought up in front of the trial judge. And unless you can show some unusual circumstance, the trial judge in that one limited aspect, not the entire appeal, but in those post-conviction motions, in most states we call it a motion for new trial. There they call it a 902 post-conviction motion, I think. And they require you, for example, ineffective assistance of counsel, jury issues, certain issues that you bring those up with the trial judge and give the judge a chance to correct the error. The philosophy is that the judge has all of that information and knowledge fresh. They know how things went down. They would have talked to the individual jurors. If it's a juror issue, they would have seen the witnesses if it's a particular witness. Tracie, the question was, why on motion for new trial, post-conviction motions that have to be brought after trial but before direct appeal, why the trial judge who heard the case also determines if they made a mistake or not.
Well, essentially, it's because they know that that's not going to be the final decision. I mean, that's just how it works, is that the trial judge gets an opportunity to remedy any mistakes that possibly took place during the trial. And if he doesn't see any, then when it goes to an appellate judge, then, I mean, that's just how the system's set up in general, is that you have the trial court, and then you have the appellate court that oversees the trial court, and then you have the Supreme Court that oversees the appellate court. There's a system of checks and balances, and so that's why. I mean, post-conviction still starts with the trial court immediately after a trial, if I'm understanding this question right.
You are.
Yeah, okay. Immediately after a trial, the lawyers will say, without fail, they will say that they're filing a notice to pursue post-conviction relief. And that post-conviction relief is not an appeal. That is something that you're going back to the trial judge and just bringing up the original issues that you saw with the trial, the things that you thought were unfair or whatever that the judge ruled not correctly on. And then the judge will rule on that, and then it goes to a direct appeal where you can appeal all of those issues. So that's why. I mean, it's just, I know it seems a little weird, but I mean, it's just giving the judge an opportunity to fix any mistakes they may have made.
Yeah, and then, maybe they didn't know how to ask this, but if Judge Willis hadn't resigned, the 97406 motion would have been in front of Judge Willis.
Right.
And it's just the way that
Works.
it's done. And people have a harder time understanding this because now you have that trial judge who's having his decisions, I don't want to say attacked, but questioned. And they're supposed to be. They're.
It's a good thing that wasn't something else.
They're hearing testimony and determining, did this person, did the prosecutor fail to disclose evidence? Did an attorney not do what he or she was supposed to do? And
this is why Kathleen has said repeatedly that cases are not won in the circuit court. They're won in the appellate court for this reason, because she knows post-conviction is before the same trial judge, usually.
Right. What you do is, so on post-conviction, when you are given an evidentiary hearing, the main job and focus, hopefully you can win it in the circuit court, but appellate court's got to approve it anyway and rubber stamp it. But you're laying out a record with testimony, and that's the main job. So, but that's the system. There's a lot of history and rationale behind it. I know some people it kind of doesn't make sense, but it works reasonably well. This isn't one of the situations where it's working the way it typically is, but you know.
And normally you would have one petition. When Judge S made her decision on the original petition, that would normally be it, and it would be going to appeal. We wouldn't have all of these extra supplements, motions for reconsideration, motion to vacate, all of that stuff going on. So this is a very extreme case. But in general, the post-conviction process would be you file a petition, the judge rules on it, and then you immediately go to appeal. Steve's case has just gotten a lot more convoluted than that because of all the extra supplements and all the other issues that have been coming up. But that's not normally how it would be. It would be just, it seemed like a very simple process. You present your case in the circuit court, the judge either affirms or denies it, and then it goes up to the appellate court and they either affirm or deny or reverse the lower court's decision, and that's how it works. Steve's case has just been very complex.
Well, and there's this thing about a little knowledge is dangerous, especially in post-conviction work.
That's
that
me.
he knew enough to file it.
Right.
He knew enough to get some issues out there. But you know, when you file these things because of this big swing in courts all across America and only wanting one post-conviction petition with collateral attack, you know, they don't want successive 97406 petitions.
Did we describe that enough for everybody that they understand the difference between a direct appeal and a collateral review? Because that was something that was brought up in this recent brief. Did you talk about that?
Yeah, I did.
Okay.
Going through the procedural hearing, we talked about that he had Stephen. We talked about on some channels, you hear some people will say, you know, Stephen's never gotten an evidentiary hearing. He did get an evidentiary hearing on a post-conviction ineffective assistance counsel, and right. Dean and Jerry came in and testified. And, you know, they argued to Judge Willis that they were ineffective in the way they handled the juror issue. That was a post-conviction procedural thing, pre-appeal. And then they appealed that. And so I explained the difference between what post-conviction counsel is and appellate counsel, because we get to an issue on that. It's the one you're talking about. We'll get to that in a minute.
It's just really important to know the difference. That collateral review, which is what the 97406 is, that's also what Brendan's writ of habeas corpus petition was in federal court. Those are considered collateral attacks. They're not direct appeals, and there is a difference of what you can present in those issues. And essentially, to put it simply, is that under direct appeal, you can still attack the verdict. Under collateral review, you can't attack the verdict. You're actually attacking issues collateral to the verdict, which means like you're attacking constitutional issues and things like that. So that's why the state actually put in this brief that you're not retrying the case and you're not determining whether Steve's guilty or innocent, right. Which sounds ridiculous to us, because shouldn't it always be about whether he's guilty or innocent? But that's not what collateral review is. I mean, you essentially have one chance to attack the verdict, and that's on direct appeal, and that's it. And once that's done, then you have to find other ways to try to get relief, and you use these constitutional issues. And through a 97406 is the state remedy for constitutional violations, and then the petition for a writ of habeas corpus, which is a 2254 under the federal rules of appellate procedure. That is the federal route that you can take for constitutional violations. And they are different. And again, this is just all about procedure. And sorry if I confuse people, but I like to try to make sure people understand that's the difference between the two.
So this appeal is
not really an appeal.
So this, what they're doing right now is a collateral.
Yes, it's a collateral review. So it's not attacking the verdict. It's not talking about his guilt or innocence, even though it seems that way because of all the stuff that Kathleen has presented. But it's actually attacking issues that are, like I said, like adjacent to the verdict. It's things that happened during the trial and things that happened pre-trial and post-trial that violated constitutional rights. That is what you can present in a 97406. You can't present like an issue like, well, like an actual innocence claim or anything like that. That's just not allowable. We don't even have an actual innocence statute in Wisconsin.
What?
No, we don't have an actual innocence statute at all. You can't file a motion for relief on the grounds of actual innocence. That's not something that we have.
Why is that not a thing?
Because they don't want to accept that wrongful convictions exist. Travis, do they have that in Texas? Do they have an actual innocence statute yet?
Yes.
They do. Yeah, Wisconsin's just stupid. Wisconsin does not have that mechanism to assert actual innocence.
As a matter of fact,
Sorry
July
for
5th, there's going to be a 5-part series on a wrongful conviction, sexual assault of a minor case that happened in Cedar Park, that I was right in the middle of all of that. And you have to get through a gateway for actual innocence, but it's not easy. But Missouri has the same thing. They talk about getting through the gateway, but yeah, we do. But it's a very high bar.
Yeah, it's not something that can actually be easily overcome, but Wisconsin doesn't even have it. So that's why you can't ever file a petition stating that you're just presenting evidence of your innocence. You can't do that. That's not what the 97406 is meant for. That's not considered collateral review. So we just do not have that procedural mechanism in Wisconsin. And it's frustrating because a lot of states do. And same thing with in the interest of justice claims that we mentioned a little bit before. Those cannot be presented in the circuit court. Well, you have to start in the circuit court. So the only way to have your conviction overruled in the interest of justice is if the Court of Appeals does it or the Supreme Court does it. But you still have to use a 97406 to even get to that point, even though they say that the 97406 is not a statute that can be used in the interest of justice.
Yes, so Texas has a specific statute on a specific statute. What Tracie's saying, a lot of states like Texas and others, after DNA came in, with the help of Innocence Project and whatnot, on how legislators got information. Okay, well, if we can prevent and fix injustices, okay, then what will allow DNA testing and will preserve stuff? What else can we do? And the recommendation was, well, pass and adopt a statute, a mechanism for actual innocence. Mm-hmm. Some states did and others didn't for a variety of reasons. So in Wisconsin, even though it doesn't have a specific statute and a specific mechanism, what post-conviction counsel do is file it under 97406. Mm-hmm. And if you show, on a DNA case that it's a slam dunk, you put it in the Supreme Court's lap, and by fiat, they grant it, even though it's not specified.
Well, it's still presented as newly discovered evidence. I mean, it's still presented as it's newly discovered evidence. So that's why they can get away with that. At least they can get away with something.
Right. But it's scary because maybe if something got tested, there was the technology, but for whatever reason, it didn't get tested at the time. And then, then they start looking back, well, you got to have a good reason why you didn't have this tested at the time as well. I didn't know, I thought my attorney's going to take care of it. They seem to be pretty soft on that and not as form over substance like they are with successive 97406 motion.
Right. Now, Julie, I know you were busting at the seams before. So what were you trying to say about, like, I mean, I know it sounds very unfair, and I think it's really hard to make people understand. Make people understand.
I just don't understand how it's not a thing that you can attack the verdict based on the fact that, look, here's evidence that I'm actually innocent.
Right.
Especially considering the fact that anytime people talk about, not all people, but people talk about, well, you know, if you get convicted or whatever, there are options available for you to appeal the decision and right the wrong and clear your name and et cetera, all that bullshit.
Mm-hmm.
But what they don't talk about, and the cops even say this to people too, well, you know, if you really didn't do it, then you don't have anything to worry about. Bullshit. Because what they don't talk about is the fact that there are all these limitations in place. And even if you are innocent, that's not going to matter, because
Right.
you have to present it in this specific way, and you have to meet these very specific regulations. And even if the law enforcement and the prosecutors, even if they acted in a way that was immoral and unethical, that's not going to matter, because you have to prove that they did it because they were trying to get at you or
Right.
whatever. Like,
And that's
I
what
don't understand how that's okay. Like, how are we as citizens allowing this to stand?
Right. And that's what my whole argument was. My whole rage thing was about the other night when I did my live stream on Thursday, was that we don't have the mechanism to file any type of petition for actual innocence. Even our habeas corpus statute is really weird compared to everybody else. We have this 97406, which is very clear on newly discovered evidence, and then yet it has this very narrow scope that it's not that it just has to be something that wasn't available back then, back when the crime actually happened. It has to be that your lawyers, if they had done their due diligence, couldn't have possibly found. And that's where we're running into a lot of problems with Steve's case, is that Kathleen has found these things, but his lawyers could have found them as well if they had done their due diligence. And unfortunately, that also falls under procedural bar. And that is what is killing Steve's chances right now, is that, and so then you try to remedy that by having an IAC claim, an ineffective assistance of counsel claim, but those are so difficult to overcome, because essentially the judge has this subjective view where they get to say, well, we believe that was just trial strategy, or we believe that that was just, you know, the way that the attorneys decided to do it, and just because the outcome didn't turn out the way you wanted, you don't get to go back and second guess your attorneys.
But it doesn't make sense that the attorneys actually submit a statement saying, actually, that's not what we were doing. It wasn't.
You think, Julie, stop being logical.
Oh, I'm so sorry. Apologies. I apologize for that.
Don't get crazy on me right now. Yeah,
I know.
Start thinking like a lawyer.
Yeah,
Don't be logical.
That would make sense. And if you can have the lawyers actually testify to the fact that this was not trial strategy and that they were just doing this for whatever reason, it won't matter. And in this case, it didn't matter, because especially when it came to, and I'm totally jumping ahead, sorry, but I'll forget things if I don't mention it while I have them in my head. But this is exactly what happened with the CD issue, where they said that the judge made the argument for the state for them. They never asked for a response for the state on the CD issue. And yet they filed an order that said that it wasn't done in bad faith, and that, you know, that they're, and they even said it should have been filed under an IEC claim. And I know that it was mentioned in this, in the 35 pages I read, I know it was mentioned in this brief, where they just specifically pointed out that Kathleen did not make an argument for IAC on that claim. She only made it a Brady violation. And again, the state's not wrong. She did do that. It's one of the things I kind of complained about at the time. I'm like, why didn't she file this as an IAC claim? Because it seems to make more sense to file the CD issue as ineffective assistance of counsel as opposed to a Brady violation, because we know that counsel had that information. They just didn't use it and didn't look at it close enough.
Here may be the answer. Here may be the answer why. So I'm glad you brought that up. Buting and Strang have both given affidavits. The affidavit said, yeah, if we had that information, we could have properly cross-examined Bobby, and we were prevented from doing so without it. As part of that same affidavit, they both acknowledged IAC, and the code language for that is, I was asked by Zellner or whoever if I could explain any strategic or other reason for failing to do such and such, and I could think of none. So the point is they have helped out Zellner with these affidavits and both acknowledged IAC. There may have been some give and take negotiation with the affidavits. I don't know. There was a lot of cooperation going on with that. And, you know, it's just one of those things behind scenes that you see in an affidavit that, yeah, I would have been able to, you know, maybe she just made a judgment call that she saw it stronger as a Brady than an IAC. And because she was getting IAC from Strang and Buting in their affidavits, you know, it was just a judgment call to make.
Okay, so
on this slide, while Tracie's here, so this was my predicted response when we were preparing this last week. It turns out the brief came out on Wednesday, and we were going to do the show on Thursday. But you know, those are the things that we were predicting with regard to the order not vacating it. And a lot of people are under the impression that the state's brief is the judge's brief, or that the judge wrote it. I've heard, which, you know, it's understandable because basically they're defending the order. And, you know, they're following along. I put up at the top here on this first issue, if they take a position, I didn't even know if they were going to take a position because they didn't oppose the motion to vacate. They wouldn't join in it. But I'm like, there are certain schools or certain areas of the country where, you know, lawyers, there's still a lot of collegiality and respect and professionalism. And if you and your opponent were going down the road and you knew what road you were going down, and you were both in agreement with it, and all of a sudden the judge did something that was clearly for the benefit of one, that wasn't really the fault of either side, you know, this is totally was a gift that dropped in the state's lap. You know, they were working on a stipulation and working on an order, working on dropping claims, adding claims, narrowing claims, and then all of a sudden the order comes out of left field. Yeah, you know, should a letter have been sent that day? You know, on and on. But you know what I'm saying, Tracie? It's like, so I was wondering, I wonder how hard of a position they're going to take on that. And we saw the answer.
Yeah, they're going to go by the letter of the law. The absolute letter of the law. That's what it's going to be. There's going to be no room for mistakes. There's going to be no room for, like I said, just making accommodations because maybe the truth is something that's in there. and not saying, well, we understand that procedurally this might be a little off, but what you're saying is important. That's not happening.
Right. And then the other practical aspect of it is, Kathleen gets on the phone and finds out where Fallon is on sabbatical. And it's like, I can't believe you all are doing to me. It's like, hey, don't talk to me. You're preaching to the choir. I think it's bullshit. Talk to the lady in Madison. It's not me, because it is, the appeals being handled by the AG's office and, Fallon's trial counsel. By the way, the attorney that people have been asking this a lot. I don't know if it's come up today. There was 2 attorneys on the appellate end of this for the state up until a few months ago, and one sent in a letter saying, hey, I've got a new address. And people are speculating, well, why'd she get off the case, or what's happening? She just wanted to do more trial law. She's an assistant district attorney in Eau Claire, Wisconsin, practicing and trying cases. So it's nothing other than that. Next slide.
Yeah,
we
we
have
have
any other
to move on with the slides. Sorry.
I know. I was like, where are we?
That's why when I start talking about I just jump all over the place. Sorry.
That's
All
okay.
right, so we've already gone over some of this, but so here's the 97406 and where this came from, but this is going to weave back into Julie's rant. So both the legislature and the courts have placed limits on a prisoner's ability to bring motions under Wisconsin statute sections 97406, which is the subsection 4 is what we're going to be seeing over and over and over again throughout this brief. That statute came in 1969. A lot of states started adding limitations on post-conviction collateral attack within their own state. And then 1969, the statute came out. It said all grounds for relief available to a person under the section must be raised in his or her original supplemental or amended motion. So they contemplate supplements and amendments, right. Because you can only have one. Any ground finally adjudicated or not so raised or knowingly, voluntarily, intelligently waived in the proceeding that resulted in a conviction or sentence or in any other after the time for appeal, that's from something else. I messed that up. But basically, you got to bring it all in one motion, or you have to have a good reason why you didn't.
And that's the thing that the state's trying to do, is that they're acting like every time Kathleen filed a supplement, she was trying to file a new motion, and she wasn't. It's all still part of the same appellate, they said post-conviction mechanism. It's all still under her original 97406. And I get why that's confusing, because it seems weird that 2 years later, she can still be filing a supplement that is really just going to be added to this original petition. But that's what's happening. And yet the state acts like she's adding all these additional appeals, and she's not. They are all these supplements, everything, all of the modifications that have been made, all the things she's added have all been still added to the original 97406 that she filed. The only question is whether or not those things should have been filed in the previous pro se petition.
Right.
But
so
again,
that quote on that top part,
or had Stephen known about a lot of those, they would have been filed. However, they were not, because the state was hiding them and nobody knew about them. I just want to throw that out there.
Yeah. Sorry, I was laughing at Fen's comment.
Yeah.
She likes how we're not in costume anymore.
I totally cut you off, Travis, but
no, it's okay.
I mean, it's
1969.
Yeah.
And then
the reason they did this, hold on. The reason they did this is because at the time we had no appellate court procedure. We had no appellate mechanism. We only had a state habeas corpus petition, and essentially everything was going to the Supreme Court. everything was going to the Supreme Court, and the Supreme Court is like, we are like way too overrun with cases right now. We need an intermediary court. And that's when they decided to take our state habeas statute and kind of use it for very specific reasons, and instead replace it with this 97406, because they wanted the appellate court to have to deal with a lot of these post-conviction procedures and not have the Supreme Court have to review everything. That's a whole reason why this 97406 came about. I don't know why they didn't stick with a state habeas procedure, just like every other state has. Now, the only reason that our state habeas procedure is used is if it's ineffective assistance of appellate counsel. Ineffective assistance of appellate counsel. I gotta make sure it's
night petition.
a night petition. Yes, that's the only reason. And then you file a habeas petition. Otherwise, it's this 97406, which, for all intents and purposes, is the same as Brendan's federal writ of habeas corpus, and it's the same as most states' habeas petition, state habeas petition. But Wisconsin, as usual, has to be weird.
No, most states have a statute. Most state, like Texas has they've
It's not
converted.
under their habeas statute?
They converted it from a habeas to
Okay.
a post-conviction statute that's strikingly similar to Wisconsin's. You know, you got to bring it in one motion. If you don't, you got to have a real good reason. But now maybe a lot of other states don't. But so that's in 1970, and then 1994, along comes the case Escalona Naranjo.
Yeah.
And Tracie can tell you all about that case, but that's when they really started enforcing it in Wisconsin hard. And that is when a lot of states had habeas reform. And that's when the federal government had habeas reform in the form of EDPA. And they all of those talk about finality being important, that excessive post-conviction motions, again, collateral, is just too burdensome on the court.
And I do get that. Like, I don't want to go through and say that I don't understand, because yes, when you think about it just from a standpoint of looking at all the people that are guilty, when you think of how many times they pursue post-conviction relief, you know, you obviously don't want the court to be burdened by an endless string of post-conviction petitions. So that's why they have to have some rules. But things need to change when we are in this culture where we know a lot of wrongful convictions happen, and that's where Wisconsin is still in the dark ages.
So this is before wrongful convictions by DNA was really picking up. And when I say, I'm saying the general public, this is the start. And why we're at where we are today, in my opinion, is tough on crime started with Barry Goldwater, used that term in a speech in the early 60s. And then in the mid 80s, it started getting picked up in campaigns. And the presidential election cycle had a huge ad about somebody who was paroled by one of the candidates who was a state governor, and Dukakis. Anyway, it started with that, and it's been on a roll ever since. But that's when people want to know why it is where we're at. That's where it's at. There's a whole bunch to go. Do you want to just start asking questions here, or you want to keep rolling forward?
Let's finish the presentation. Let's go through the presentation. Just try to keep it as brief as possible, because we're over an hour and a half already.
Yeah, we're way into this. So.
Go for it.
Are you expecting me to read?
No.
I'll
Go Travis.
Go Travis. Go Travis.
Go Travis.
Tracie's been
Okay,
drinking.
that's just another way. That's from the decision.
Sorry.
No, keep going. Next slide.
Oh, next one?
Mm-hmm.
Okay.
We already kind of, yeah, we talked about that already.
Okay.
Okay, so go ahead.
Yeah, well, for this, I mean, I talked about this in my video, but I mean, this is, I don't know how to say this quickly, but I'll just say it very briefly as I can, that this whole problem right here is that they acted like Kathleen brought up no reasons when she actually brought up some reasons, and she did explain.
Let me stop you for just a second. Hold that thought, because
Yeah.
this is, I'm pointing out Zellner's brief, issue
Right.
7. So this is an example. Zellner was anticipating the state coming at her with a procedural bar, and it's issue 7. And if you want to read about it, she knew this was coming, and so she laid it out all ahead of time. And now, go ahead, Tracie.
Well, and that's why I said she was just, like you said, she was anticipating the fact that they were going to make these arguments, because what other argument could they make? They were saying that it was insufficiently pled, and that Steve did not give enough reasons as to why he could not have brought these issues up in his previous pro se petition. And Kathleen did give reasons. The state is still trying to say that she still didn't provide sufficient reason, meaning she said that he had a low IQ, he did not possess the legal acumen, whatever else she said about that. But apparently the state thinks that there should be more proof of those things. And one of the things that bothered me about that is that the same judge ruled in Steve's pro se appeal, or God, shoot me, pro se post-conviction motion. It's not an appeal. But the judge is the one that said, basically, and being as sarcastic as possible, is like, Steve, you don't know what the hell you're talking about when it comes to the law. Like, nothing you presented actually follows the law. You have misunderstood and misconstrued everything. You have like presented everything incorrectly. So this is the judge that's actually saying this, where she's basically, you wasted my time because you don't know anything about the law and you have not presented anything correctly. And yet the state is arguing that there's no proof that Steve did not have the legal acumen to be able to properly present a post-conviction petition. And yeah, go ahead. Julie, go ahead.
Except what the judge said.
Right, that's what I'm saying. It's like, it's so weird because you have the judge essentially saying that, yeah, he did not provide any type of cohesive legal argument that made sense, and yet then the state is using the argument that, well, there's no evidence of the fact that Steve does not possess the legal acumen, which I have to laugh when they say that, because come on.
Have they met him?
Yeah, exactly. That's what I'm saying. Come on, read that pro se petition.
Have they met him?
Yes, and I joked with Steve about the same thing, so I don't feel bad about saying it, because Steve thinks he knows a lot about the law, but I was like, Steve, I've read your pro se petition. Stop. No, you don't know what you're talking about. And Kathleen actually said that in her original brief, when she said that, like, Steve improperly presented arguments. He cited the wrong case law. He misunderstood the statutes. She said these very things. And so for the state to say that she didn't give sufficient reason, well, those are the reasons. They're just acting like she didn't say anything. And this is what I said to you before when I said that you don't have to present a dissertation on every claim. You don't have to go into great detail of every claim. You just have to be able to say that this is a claim we're making and this is why, and then give some examples as to why. And that is what she did. And yet it isn't just for this one issue, but for everything they're saying it's insufficiently pled. And as what did you expect them to say? I mean, like, you can't go on for 30 pages about every claim. You just can't. You say what you need to say, you attach the affidavits as proof or whatever, and then, you move on. And the state is trying to say, like, Kathleen's brief was too long for it to not have anything that was of sufficient, anything that could be considered a sufficient pleading. And yet they're acting like Kathleen was a first-year law student who didn't know what the hell she was doing, and doesn't understand what sufficient pleading is, and doesn't understand the statutes, and doesn't understand anything about post-conviction law. And so it's a very insulting brief on top of everything else. But that's how they're acting. They're acting like they're like laughing at her. And I think I said in my video that they're thumbing their nose at post-conviction procedure with this whole thing.
Next slide. So the state's response to her issue 7 was explaining the good reasoning, as Tracie just laid out, for those things not being brought in Stephen's pro se motion and why they should be heard in a second 97406 motion. That's 85% of their brief, is they're attacking everything. And you'll see later, I just start initialing it as piecemeal PM and procedurally barred PB. Next slide. We're not going to go through all of the Brady things, but I do want to bring up one example. So the standard of review, what is that?
What is what?
I heard like a ocean wave or a.
My husband using the microwave. That could be it. I don't know. I'll mute my microwave.
My fan's on, my window's open, but I didn't hear any noise here.
So there's this standard for Brady, and you know it's set out in both briefs. If you're really interested in the law on that, you can read the briefs and they'll explain it. But it can't be just anything that's hidden or you could use for impeachment. It's got to be material. And material is, and that's what Zellner kept saying, and Ma'am too, undermines the confidence of the verdict or judgment. It's reviewed de novo, which is good because it's a legal issue. That means the Court of Appeals doesn't have to take the circuit court's judge's view of something like a factual question. They get and have to look at it brand new, which is what de novo means. So that's a good thing. Next slide. All right, so those are the original 5 Brady claims, plus the one she got on remand, the CD from the computer. We're going to do an example, and this is on cognitive and confirmatory bias. This just happened to be an example with regard to Kathleen, but so with regard to that, is that pronounced Heidel, Ms. Heidel affidavit?
I don't know.
Yeah, I think so. Yeah.
Okay. Well, people don't remember Ms. Heidel was the one who did an affidavit that she was on the phone with Teresa Halbach. They were talking about something, and that Teresa pulled off to the side of the road to write something down in her calendar or day planner. And then from there, what happened is that kind of bled over into that Ryan Hilligus had the day planner, which means he had access to the car after her death. So the state takes a big swipe at her on this affidavit. They point out that in Kathleen's brief at page 48, the argument is, quote, Ms. Halbach pulled her vehicle over to make notations on her day planner as she engaged in conversation with Ms. Heidel. There's no evidence that Ms. Halbach returned home after this conversation. Goes on to say Hilligus was in the possession of the day planner after the murder, according to one of Ms. call box friends. Well, the state in their brief basically say that's not what the affidavit said. So we're going to have to, at some point, in the next couple of weeks, go back and look at where this came up. Is it's Exhibit 45 to one of Kathleen's motions or supplements or motions for reconsiderations. Affidavit. If we had the appendixes, by the way, we could just look in the appendix without any hassle. But and
someone needs to get a copy of the appendix. I would really like to have it so I could post.
That is going to be expensive if you want a copy of the appendix.
It's going to be a fortune, but anyway. Yeah. But they take a major swipe at Kathleen on that, saying, she's playing fast and loose with the record, that she's not being honest, and and there's two mentions of that in the brief and footnote where they say, yeah, look at the affidavit. She never said that. Heidel never said that, she knew that Kathleen was writing this stuff down in a day planner. But I think a lot of us, from hearing supporters and whatnot, it jumps to that. And I only bring this up is that there's a big difference between talking about things amongst supporters and putting something in court.
I'll just go on the record to say I don't think she's going to win on a Brady violation.
Yeah.
That's as short and sweet as I can keep it. Like, I don't put a whole lot of stock in Brady violations.
What do you think the strongest Brady out of all of them are?
The day planner. But the rest is not. You're not going to win on the CD issue for sure. Absolutely. Because the defense had that. There's no way you're going to win on Brady on that. And yeah, so I think that the strongest one is probably the day planner, but even then, I just don't think they're going to win on a Brady violation at all. I think an IAC claim on some of those is stronger, especially on the CD issue. The IAC claim is stronger than the Brady violation.
Yeah. So, the general tendency would be, oh, well, if the state said, Zellner's being inaccurate about what it said, and you just automatically discount that. You can't. At some point, we're going to have to go back and analyze that, and we'll know for sure with the reply how she addresses that. But
well, what do you think? What do you think is the strongest Brady violation? None of the above.
I could see some traction with that Visconti summary. I'm with you. I don't think she's going to get it sent back for an evidentiary hearing on Brady. I think it's going to be IAC. And I think also it's going to be sent back on the Youngblood preservation statute.
Yeah, I think that this case law on IAC is more with her than on Brady.
Yeah, because it's cumulative.
Yeah, exactly.
We'll talk about in a minute. And so
yeah,
one can build on top of the other, and
right.
So they can look at all the circumstances, whereas Brady they got to look at in isolation. Okay, next slide.
Julie, what?
Sorry.
Okay, what's the response?
PB and PM. What Penny Bernstein and what?
PM is piecemeal, and
I was like, PB. What is that? That's Penny Bernstein.
PB is I just said it.
Don't make me think. Come on.
Procedural bar.
Travis did.
Oh, procedural bar.
Procedural bar.
Yeah.
Oh, you want a stat? You want a little stat?
Sure.
How many times does the state brief mention Escalona versus Naranjo?
Well, they referenced Romero a lot more, didn't they?
I don't think. Well, maybe.
close call between that and Escalona. I mean,
11 times. How many times do they use the phrase, can be either one, I counted them together,
Oh,
procedurally barred or procedural barred?
a lot.
I quit counting at 40.
Right, and that's going to be under Escalona or under Romero, one of the two, depending which part of the fit you're talking about.
Yeah.
I just want to interject for our two attorneys here, or basically attorneys. This is a simplified and summary, a simplified review and summary. So don't go too far in the weeds.
Okay.
I think we've already
For all
passed
of
that
us.
point, haven't we?
Next slide.
I always get too far in the weeds when it comes to that.
We're trying to be simple.
I know. I'm sorry. Oh, hey, I'm good at that. I'm good at simplifying things, sort of.
Yes, you are.
Yeah.
Okay,
I would
so
like to say
Travis still talks like a lawyer.
when
Yeah.
I post the summaries, the simplified summaries on workwithkz.com, especially at first, I would always check with Tracie to make sure that what I was posting was accurate. And she was really good. She was my inspiration for wanting to post that website, because it was great that she would analyze it in simple terms so that people can understand it. People who are not lawyers can understand exactly what it's saying. And that was the whole point of the website. So Tracie is very good at that.
And thank you, because I always told Travis and Wendy that no matter how hard they try, they still talk like lawyers.
yeah,
Yeah.
I've said that over and over and over. Nobody explains this stuff better than Tracie. But so her third claim is ineffective assistance of counsel, which we've been mentioning throughout, and the grounds she stated: failure to hire experts. What the case law is on that, you can go in and read that if that's of interest to you. The law on it, what experts she felt that they should have hired. There was a little swipe in there the state made about that Zellner in one brief or affidavit said that trial counsel were paid $220,000, and then in another pleading $237,428. Just a little dig that the money that they were paid was off. And of course, the state feels that Dean and Jerry are the best trial lawyers on the face of the planet, which everything was strategic, but all of that's kind of review. We've seen that, and it's talked about regularly. Did you have anything you wanted to add on that issue?
No, because I'm just going to go with the same thing. When it comes to IAC, the state completely blew past State versus Thiel, and I think that is where the strongest claims are as far as case law goes when it comes to the things that KZ is stating. And for those who haven't watched my previous video on State versus Thiel, that is the case law that states that you have this is the last thing, is the cumulative effect of all of your IAC claims. You don't have to win on one claim. That when you file specific, like several claims, they can all be taken into consideration together. And now I'm drawing a blank on everything else, Travis. So I can help me with
that. And that Thiel, Thiel, and
sorry, my brain is broke, so I try, but I just talked about the other night, and now it's completely gone right now.
Next slide.
I'll just drink more. Sorry.
What's their response?
Oh,
I'm
sorry.
going to post a link to that video that Tracie just mentioned.
Yeah,
in the comments.
duty to investigate was a big one. That's what we were just talking about, because we were talking about experiments and things like that. That duty to investigate is a big thing under State versus Thiel, where they stated that defense attorneys have the duty to thoroughly investigate a case before bringing it to trial. And the other thing is, see, it's all clicking now. The other thing was that if you it's IAC, if the defense attorneys don't thoroughly review and use any discovery material, and that's where the CD would fall in. Like, I don't know how you can say that it's not IAC with the CD when it comes to State versus Thiel, because clearly they had that information, they didn't use it correctly. They didn't read it close enough. They didn't, pursue it. So those are 3 areas just on that one case alone where I think Kathleen has a really strong case, and that is the duty to investigate, and then the cumulative effect of IEC claims, and then whatever that last one was.
This is so ridiculous. Like the prosecution or the state is like, okay, we can mislead whoever we want, and we can put out as much misdirection and bullshit as we want. And if the defense doesn't combat it or investigate it or present it in specifically this way, then this person's going to be convicted. That's complete bullshit.
And it's even more bullshit when you have a judge, as in the case with the CD, and the bones, both issues, where the judge is making the case for the state, when the state didn't have to supply any reasoning for why we withheld this information or why we gave away this evidence or whatever. And then the judge is saying, well, it was strategy, or it was not in bad faith, or it was, and that's where we have the real kind of crux of the whole problem with this case, is that you have the judge actually making the state's case for them. And in the, same vein is that the fact that the state is making the case for the judge, because the state, this is probably going back a little bit, but the state very clearly pointed out, well, even though the judge was wrong on the procedural issues as far as the Knight petition goes and the IEC claims being filed in the circuit court, which was, for me, was a big issue in the circuit court's decision. The state is actually pointing it out and saying, like, yeah, they might have been wrong about that whole procedure thing, but their conclusion was still right overall. And I still look at it, well, isn't it a problem just in general that you have a judge who does not understand the proper procedures when filing an IEC claim? And so the state is right, and the state is basically saying, like, hey, judges, when you make this decision, remember to include this because the last judge was too dumb and forgot it. So it's like the state is making the case, the arguments for the judge, and the judge is making the arguments for the state. And then there's Steve, just left alone, trying to fight for himself, basically.
So in this experts, and I bring this up to show, how Dean and Jerry are working with KZ. This is page 68 of the brief. On November 16, 2017, trial counsel, Mr. Strang, gave current post-conviction counsel an affidavit admitting that trial defense counsel was ineffective for failing to hire a blood spatter expert. He quotes 9 or 10 lines. I'm not going to read all of them. I'm just going to read the end. He says, I did not have a strategic reason, because remember, strategy reasons, decisions can never be ineffective under Strickland. I did not have a strategic reason for not considering or hiring such an expert or experts. And then Jerry has another one on another. Next slide. We can skip that. It's the, well, let's see. That's a night hearing. And actually the state raises a totally bogus claim.
Oh, yeah, that's what I was just talking about.
Saying you can't bring a post-conviction ineffective assistance. You can't bring an IAC claim for a post-conviction issue, which is wrong. You can't bring an IAC claim for an appellate issue. And the court's clear that, and that's where you use habeas, right? In Wisconsin.
Yeah, that's the habeas statute.
A night petition. So this is what, in the case, the big case on this is Rothering. Appellate representation consists of two functions: writing the brief and delivering oral argument. This is distinct from post-conviction representation, sometimes called post-disposition representation, which refers to an attorney's role in filing motions with the circuit court immediately after his client has been convicted and sentenced, but before an appeal to the Court of Appeals. And it says, and she keeps saying, it's clear you can appeal a post-conviction IAC issue or post-conviction issue under 97406. And they keep saying, no, you have to bring it under night.
To keep it simple, my only response to that is the judge was dumb. I've been saying that since the beginning, that she totally screwed up on that ruling, and now the state is trying to fix it for her.
And not confessing error, or, well, you know, they do cite the proposition that
even, and they do say that the court may have been mistaken in its procedural description of this, but their ruling is still correct. That's what they kept saying.
Well, yeah, they cite the law for that standard. Even if the court comes up with an incorrect reason, if on appeal you can find a valid reason, then it sticks. Okay, next slide.
Julie left.
Oh, got a question?
Is there anyone else doing the slides?
She's back.
Yeah, she's back.
Hit the slide, Julie.
Travis decided to go move a slide when you were gone.
Again.
Yeah.
So that one, it was, you know, what they didn't say, you know, procedurally barred. They said you need to bring a night motion, but they never got the fact that she's correct on the law.
Mm-hmm. Now this one I'll okay, we're going to talk about standard of review again, but I mean, a lot of this is going to be reviewed de novo because I mean they're questions of law. But this one is what I was saying before about how where State versus Thiel, which I keep harping on for everybody, was saying that when you have actually this is actually State versus Machner, but that when you have an IEC claim, you have to have an evidentiary hearing, which is called a Machner hearing after, if it's just IEC, a Machner hearing in order to get the attorney's side of why they did what they did, as opposed to what this judge does, which is what she just says, oh, well, it was trial strategy or whatever. She just makes up an excuse without actually having the trial attorneys testify in a hearing as to why they did what they did. She's just filling in the blanks. That's what she's doing. And that's why it's not just that Render and Machner said that you have to, I mean, that there should be a hearing. They're saying that you have to. It's a prerequisite to appellate review to have a hearing when it comes to these IAC issues, because how can you say what the attorney's intent was without ever hearing from them? And that's what Julie was mentioning before when she was talking about, like, well, what if the attorney testifies and says, hey, this wasn't part of strategy, I missed it. You know, well, that should make a difference. And that's why you have a hearing like that. And so that's the argument there, is that, you know, they're saying that's why you should have at least a hearing on the IAC claims.
Right. And
yeah,
then
very exactly. That's what I'm saying. The judge is actually making their arguments for them. Sorry, go ahead.
And then that's exactly the way I saw it too. And then she narrows the focus on the issue on IAC with regard to failure to hire experts. And she cites that Allen case with the who, what, where, when, why test.
Right.
She lays it out in graphs. Now she cites two different Allen cases. That's the 2004 Allen case. But for 3-4 pages, all of the experts that she's retained, she lays out the who, what, when, where, and why for each expert. Looks like this. And for 4 or 5 pages.
If you'd given me warning, I could have put that up there, Travis.
Yeah, but I mean, I know what he's referring to, so that's fine.
No, it starts at page 98, and it's there. Anybody wants to see it, and then
These things hurt me.
that was the only case I wanted to discuss, that Allen case and the who, what, when, where, and why test. Unless Tracie has anything else on that.
Well, Allen is another IAC case, where it says the same thing. It says that, I think it's actually Allen that says that a hearing is a prerequisite to determining, whether there was a violation when it comes to IAC, unless the attorneys can actually testify as to what their intent was. So it just kind of falls under the same thing as I was saying before.
Next slide.
I've been drinking, so I could totally be making this up, but I sound good, right? So I know it's correct. It's actually correct.
Next slide, Julie.
So that's what
you
their
did.
response is, she's procedurally barred and piecemeal.
Yeah.
Then the next issue is, okay, so the newly discovered evidence, there wasn't a lot of substance in the state's brief about that. They're kind of conclusory about that. Have you gotten that far, Tracie, in the brief, be able to comment on that?
Page 107. I'm on page 33.
Okay.
But I bet I can still answer the question because that's how repetitive this brief is.
Yeah. So they basically just say procedurally barred and it's piecemeal.
Yeah. Which is what
the
they
other
said.
thing they say is
105 pages. Yeah.
they quote Norano again, that language about that what she's asserting isn't new evidence, it's new claims, which that's just bizarre. I mean, bizarre to take that position. They're not just new claims. I mean, there's new evidence.
I mean, to be fair, some are like old claims that she's trying to pass off as new, but for the most part, there is still a lot of stuff that is new.
Yeah. So it's global. They don't really reach down into the details of why it's a claim, why it's not, new evidence. They kind of generalize. And so not a very strong issue, but that's not a strong issue for Kathleen either, I don't think.
I think the biggest issue is when it comes to newly discovered evidence, one of the biggest things is the scientific evidence that they've completely dismissed because they think the original tests are not conclusive enough to be able to say that it would have helped him or not during the original trial had it been presented.
Mm-hmm.
And
which is the brilliance
of
no, but that's the brilliance of her brief, is that the new evidence on the expert, that can be Brady taking something that wasn't turned over, and she can turn that into Brady that the experts discover. She can turn it into IAC, which she has. Failure to hire these experts. So she is very gifted in being able to hook an expert who's able to come up with something and make at least a fairly good argument under Brady, IAC, and new evidence. And now people are seeing the importance of, well, why didn't she just make that IAC if it's better? Why didn't she just make that Brady? Or why didn't she just make, now we understand, because she may be in a situation where some of these issues are precluded because they could have been brought in the first 97406 motion.
right.
So she's got to take one fact and make it three different claims. If that makes sense, it's because she knew about this procedural bar thing coming from the beginning, and she's hoping to clear that hurdle. If she does, she's home free. If she doesn't, she's got to twist those around and, for example, say, well, there's no way Stephen could have brought up something we discovered
Right.
2017 or 2018 as part of a 97406 motion. There's just, if we didn't know about it, there was no way for him to know about it when he filed his first motion. Next slide.
I actually had a great response to that, or a great addition to that, and it just lost it as soon as I thought of it. Just thought I'd mention that, just because.
Just interrupt me.
My brain is so bad right now. Sorry. I am going to be like, Travis, stop talking. I need to say something. No, I lose
just go, wait.
Fast as it pops in my head.
Just go like, wait, and I'll stop.
I sat there trying to think of it and like, no, it's gone. Move on.
Okay, we've covered that. Next one. Their response is what Tracie said, that they deflect from they just go to procedural bar, because if they start getting into the merits and the issues of that, that becomes a problem for them. Next slide. Okay, well, so this goes back to the very, very beginning when we looked at 97406, subsection 4. They were in the order, dismissing the 97406. The judge is critical about there's supplements, there's motions for reconsideration, and she just denies all of that globally. But as we saw, the statute contemplates supplements and amendments.
Mm-hmm.
That's all I really had to say on that issue.
Well, there are issues with her motion for reconsideration. I mean, and don't ask me specifics, because I wrote a whole post about it in my group. I can remember that I wrote a post about it, but I'm totally lost on the details. But there were issues with the motion for reconsideration. I know one of the biggest issues was that she was presenting things that she intended to present in a supplemental motion for the original petition, but that she didn't get a chance to. So she tried to submit them later and then had people sign the affidavits and then post-date them. Yet you could tell that it was actually dated prior to her filing them. So those are an issue. Those motions for reconsideration are an issue, but the supplements are not. It shouldn't be an issue, because again, when she filed the supplements, that was the Court of Appeals actually giving permission to send it back to the circuit court for evaluation. So those shouldn't be a problem, and the state is acting like they shouldn't have to address anything that was after the original decision. Right? Is that where we're at least?
Yeah.
Am I making sense?
We covered that already. Skip that one. Okay, so this is her last issue, Roman numeral 10, 10 of 10, and this is the bones. That's verbatim the way she sets out what the issue is. There's an old saying in appellate law that whoever gets to frame the issue wins. And so if you just look at how she puts that, denies the supplemental motion for post-conviction relief pursuant to the statute, and I think this is one of her strongest arguments in terms of not whether it will ultimately prevail as a young blood, or that it'll ultimately prevail, that the remedy that the court finds under the preservation statute is a new trial. It may end up that all of this is determined to be harmless, but she lays out that she should have at least gotten an evidentiary hearing on this pretty clearly. I think she did a really good job on that it was an abuse of discretion not to award her that hearing.
And this was the one that made me really mad when it came to because bad faith was a huge part of this whole statute and the case law attached to it. And the judge decided there was no bad faith without ever finding out from Uyghur, from Fallon, anybody else involved, why they got rid of these bones, why they disposed of this evidence. And how can a judge make that determination without a hearing to hear from the state why they did this? And that drove me crazy. That made me so insane when I read that decision. It was like, why are you deciding that there was no bad faith when we have not heard from the state at all on this issue? And I still don't understand that. If there's ever a reason why there should be a hearing, it should be for this one issue, because you cannot determine bad faith without hearing from the people who got rid of the evidence.
Right. Then the state argues, they start to get into the logic of it under their heading C on page 110 of their brief. Even if Youngblood applied to the post-conviction destruction of evidence, which it does not, Avery has not met his pleading burden. And then they
he never did in anything, apparently.
What's that?
I said he never did in anything, apparently. Like he never met his pleading burden in any claim.
But so then they start to get into this logic on 110. Avery asserts only that if testing revealed that the bone fragments in the quarry belonged to the victim, it would establish that the victim's remains were not under Avery's exclusive control. This is the part where they refer to Brendan as a accomplice. And, you know, I was asked, well, how can they refer to him as an accomplice? And it's not an accomplice in that case. There's nothing in the record in that case to show him as an accomplice, but they have the judgment of conviction that they can point to. And, you know, they're not going to get into splitting hairs over that, but they start to try and do this logical thing that, well, if the bones are in the quarry, then that doesn't, they just get off into the tall weeds trying to say, well, you know, the testimony of, you know, the forensic anthropologist and just not making a lot of sense. And, you know, going back to what other people have said, including you, Tracie, and I know Fen and Julie, it's like, well, why are you giving these bones back to the family if you don't think they're recent? And if those bones, including 8675, the hip bone, were out in the quarry, why on earth would they be out there? And why was there so much time spent on trying to, you know, to divert away from the fact that the defense's argument was the primary burn site was not on the Avery salvage yard, whereas the state took the position that no, this is consistent with the primary burn site. I don't think the state did very well trying to come up with even if you find that it's under Youngblood and they say, and it's not, you know, the logic makes it so that, you know, this wouldn't be relevant, wouldn't be material, and certainly not deserving of a evidentiary hearing. And I that's why I think it's so strong if you can get now that issue. So let's conclude with this, Tracie. So that was clearly not an issue brought in Stephen's first 97406 motion.
Right.
The Youngblood preservation statute violation. And Kathleen claimed in December of 2018, when it came to light, that she wasn't provided those two last pages of CASA where it was mentioned bones were returned to the family. She got affidavits from the trial counsel and the, well, trial counsel was out of the case by then. The appellate counsel would have been still on the case at that time. they said their CASO didn't have those last 2 pages. The state has a uncorroborated, unsubstantiated, conclusory statement in their brief saying, well, Kathleen would have had those 2 pages of CASO. When he clearly had affidavits to the contrary, that's my recollection, which is how she got the motion for remand. So assuming she gets past that part, that it's not something she missed, that it was something that they didn't give her those last 2 pages, seems like she could bring this claim even in light of being procedurally barred, because it couldn't have been brought in Stephen's first motion.
Yeah, this was brought about because she was not given those pages that showed that the bones were given away. And I don't think the state really even argued that. I mean, I think the state went along with that, but again, they tried to say that, well, actually they didn't say anything, right? Because once again, the judge just ruled without anything hearing from the state, didn't they? Am I totally wrong on that? I can't remember.
Well, in their brief, they put in a footnote that she would have had them, and my prediction is there's going to be a real strong reply on that, saying she's probably going to use the same language that the state does on some of her stuff, that it's a dishonest representation of the record. The state's said that a couple of times, so I think she's going to come back same way. But they did quote in a footnote that nothing to justify why she didn't, she would have had this information, and nothing to justify why she didn't do anything with it until December of 2018. But right. I remember she got several affidavits to show. She got an affidavit from her office that it didn't have those last 2 pages. She got an affidavit from Kirby, one of the Kirby guys, saying, I picked it up, it didn't have those 2 pages. And then one of the appellate attorneys gave an affidavit that those last 2 pages. Now, I don't want to say what the other thing is, it doesn't really matter, but I think she's gonna have a really good, strong response to that in her reply. What do you think? So the next steps, you can go to the next slides until we get to next steps, wherever that is, Julie. The next steps is she's got 15 days plus possibly 3, but 15 days to file a reply. Do we think Kathleen will file an extension, maybe try and get another 15 to 30 days? And
she may file one 30-day extension. I wouldn't be surprised if she did. But if she files in 15 days, I wouldn't be surprised about that either. It's not like she wasn't expecting this to come through at this time. But now remember that her reply can only be in response to anything that was in their brief.
Right.
So
do you think she'll need a word extension? Because the reply is severely limited.
Yeah, probably.
So you think we'll probably see a word extension at least?
Yeah.
Okay. So I looked at all the cases that have been decided since January by any court of appeals in Wisconsin. And
can't be many with a pandemic. There can't be a whole lot.
There was just 15.
Okay.
And I went back and re-reviewed it today. There's some encouraging news, but this appeal, everybody, is way different than the normal criminal appeal they get. But they say they go in chronological order. I don't know if that's true or not, but there was a case, it's called Mullen, and it was a bright light got shined in the back of a vehicle and by a police officer, and whether that's a detention or not. It's a fairly straightforward issue. The appellate brief was filed in November of 19. The respondent's brief, February 3rd of 2020. The reply brief just 10 days later, February 12th, and decision 3 months later, May 20th. I don't know if they're normally that quick or they're slow right now or what. When I was tracking it before, I thought it would be at least 6 to 9 months after the reply, assuming they don't order oral argument, which looks unlikely.
Yeah, it said oral arguments are not a given. We talked about this the other day, but oral arguments are not a given in the Court of Appeals, in the state Court of Appeals. In federal Court of Appeals, it's pretty much common. It's the norm. But in state Court of Appeals, oral arguments are not a given, even though Kathleen has said, I've seen her say in interviews that there are going to be oral arguments. Well, it's not a given. This is a very complex case. So if there was going to be a case where they were going to have oral arguments, this would be it. I would say it's a good sign if they ask for oral arguments. If they don't want to have oral arguments, I would say that it's a very bad sign in general. That means they're going to make their decision on briefs, and that's just not good at all. If they want to hear more from the attorneys, that means at least they're keeping an open mind and they're willing to consider both sides. So, but yeah, it's not a given, and it's even though it's rare, I would expect for a case that's this complicated that they would have oral arguments, but again, it's so unheard of that.
And the last point I had under next step is, regardless of how it comes out, probably one side or the other will appeal the Wisconsin Supreme Court. And again, it's discretionary, but
it will be denied. I'll just put it out there. I'm yawning, but I'll be like, it'll be denied. Whichever side appeals it to the Supreme Court, the Supreme Court's not going to take this case.
Okay, so let me ask you this, Tracie. I think this is the last part. We can answer some questions from the people, but people, in going through both briefs, people may be wondering, well, and I understand these are issues and topics that people talk about in a different context, but we're talking in the legal context, the briefs, but there's no discussion from either side about there may be more than one RAV, for example, or that there were different lawyers in the case for either the state or Avery at trial that there are on appeal, or that the death may not have been scientifically proven at trial. There's not any, you don't see these types of things in the brief, even though they're, or the conflict of interest that the Manitowoc County Sheriff's Office had, but yet they were still involved in the location of the critical key and other critical pieces of evidence. Why is it that these things, even though they're commonly discussed as problematic for a lot of people in general discussion, why aren't they in these very important legal documents, the briefs?
Well, because Kathleen has decided that they're not an issue. That is the very short answer, is that we may discuss, or people may, not me, but people may, let's be clear.
No,
but people may discuss that there are two different RAVs. They may discuss that Teresa's alive, whatever. But Kathleen has never made those assertions, ever. That means that is just dead in the water. Like I don't want to say there's no point in discussing it, because people like to discuss those things, but that is not something that legally can come into play at all, because Kathleen has not brought them up. And if she wasn't procedurally barred already, she's definitely going to be procedurally barred in the future from bringing up these issues. So, yeah, she has never tried once to state that Teresa's still alive, and she has never stated that there's more than one RAV4. So those are issues.
I worded the thing on Teresa, that, some people say, but like people who are knowledgeable in science and whatnot, one of the problems they have is like, well, they didn't prove she was dead scientifically. And, I try to explain, well, yeah, that's true. They had the sister come in. When's the last time you talked to your sister? October 31st. And that's all you need. we got rid of no body, no crime. That's Hale's law, by the way, from England. We haven't had that in over 100 years. All you need is somebody who's missing and one weak piece of corroborating evidence. And so it wasn't an issue for trial counsel. It wasn't, and it's not going to be an issue for appellate counsel. So I agree with you 100%. They're either things that for KZ, the forensics didn't lead her to, or they were never a legitimate trial issue to begin with. But that's why they are probably not in the brief.
Right. I mean, those are things that, as far as I know, Casey's never questioned. She has never questioned whether Teresa's alive or not, and she's never questioned whether there are multiple Rabs. Whether she should have or not is a completely different discussion. But she has not personally felt like that is something to pursue. And since it was not presented in this petition or any of the supplements, it's an issue that's just, like I said, it's dead. There's no point in even bringing it up. I mean, again, I don't want to say there's no point in discussing it, because I know people are interested in that. And from that respect, I can see why they talk about it. But as from a legal standpoint, those are issues that are not even in play at all.
So is the color of the RAV of legal significance?
No, because I mean, like I said, this is something that could have been brought up in his direct appeal, or even in his post conviction. I mean, this could have been brought up so many times, and it hasn't been. And then the fact that KZ hasn't even brought it up means that it's a non-issue. I mean, it might not be to some people who are investigating it, but as far as from a legal standpoint, it is a non-issue.
It's not legally going to make any.
It's not legally going to make any difference. And maybe people might want to put their energy in something else, but we are really in a difficult position right now, because even with all the people that are researching and getting a lot of FOIA requests and finding out new information, this procedural bar issue is not going to go away. I mean, if Steve is procedurally barred from presenting a lot of what he presented this time, he's going to be procedurally barred from even more from presenting anything he wants to present in the future. And anything that has not been presented already would have to be presented in the future. And unless it's truly, truly newly discovered evidence, meaning something that could not have been discovered at the time that KZ presented her first petition, her original petition, it won't be regarded at all. And that's what I want people to keep in mind. Like, as far as discussing the case and looking for new information, keep doing that. Don't stop doing that, because you never know when you might find something that would be considered newly discovered evidence. But also don't get too bogged down by some of the, some of the talk about it, because a lot of times I think there's more discussion about it than when it's not even really all that important in a legal sense.
I have a question before we start looking at questions from
and we just asked the one question, because it does have to do with what Tracie was just talking about. If you're going to change the subject, are you?
Oh.
Are you on a different subject, Pom Pom?
I wasn't on a different subject, but now I'm trying to remember what my question was. This is
I'll answer Sappercop's question. He said if he was procedurally, what? Go ahead.
Hold on, I've got a whole list of questions here that people have been asking, so we can't jump other people's questions in first. I'm just saying. Go ahead, Julie.
Yeah. So my question is regarding the state's response. Okay.
Yeah.
The majority of the people who are here watching this video and in the chat are people who are on the same side as KZ, right? We're not on the state side. So Travis and Tracie, after having read what you have read of the state response, how right are they? Like, is all of it bullshit? Like a lot of people want to say it is, or do they have a point?
That's such a hard question to ask, because from a standpoint of justice, it's complete bullshit. From a standpoint of legally, it's not. I mean, they have a good argument as for the procedural bar. They're right. There isn't a lot of case law that suggests that a pro se litigant or someone with a lack of legal acumen shouldn't be punished for filing a pro se petition. I mean, they're right. There is no case law supporting that, saying that that should be something that can overcome procedural bar. But as far as the fact that what we want to hear is, we want to hear them discuss the issues. We want to hear them discuss the merits of the case. We want to hear them say, like explain to us why Ryan Hilges had the day planner when, he shouldn't have had it. Well, that's what we want to hear. And unfortunately, we're not going to get that from them because they're going to keep standing on procedure. So
that was actually the question. It was from Sapercop. And the question was, what are the chances that the Court of Appeals affirms for the state based on the procedural bar and ignores the merits?
It's a good chance.
It's pretty good chance they're going to do that.
Chance because they're, I mean, hate to say it, but procedural bar actually, it's a thing, and it's not like Steve's would be the first person that is worked against. I mean, everybody that files a petition usually loses because of procedural bar at some point. Because again, the bar is so high. It's not just that you can present things that weren't presented previously, but it can't be something that your lawyers couldn't have found if they had investigated properly or used their due diligence. And that's the part of the standard that's really hard to overcome, is that, and even with Steve's case, that's true. If his lawyers had done their due diligence and gone through discovery properly and found everything, he would have been fine. So you can't really present that later because, unless it's under an IAC claim, and they didn't file that. They filed it under a Brady claim, and drives me a little crazy, but yeah, so you can't, I don't know. It's a lot of intricacies to it. But unfortunately, I think the law is on the state side, and that means that's because the law is wrong. When you talk about right or wrong, it's the law that's wrong.
So the next question is from Master Crooner, and it may have been answered already. But let's try to do a lightning round here of Q&A. Question: if the state's reply to withholding the DASI computer CD is legitimate, if that's legitimate, are they themselves proving ineffective assistance of counsel?
You would think so. I mean, I even thought the judge, when the judge gave the order on that case, she originally said that it could have been trial strategy or whatever, and she actually made comments that made it seem like it would be IAC. But then so let me back up a second. Yeah, she actually made claims that it sounded like IAC, that they had this information, they did not use it properly, they did not thoroughly investigate discovery, but that they made a choice not to look at it. So she was trying to cover both aspects. She said that, that even if they were negligent in not looking at it, it was trial strategy. Like they were worried about what they would find on it or whatever. And so they made a conscious decision to not look at the CD and the contents. So the judge decided that all on her own. But her original ruling was, at first, it's not a Brady violation because the state turned it over to the defense. But in the alternative, it's still not an IAC claim, because it was trial strategy. That's what the judge said, and that's how they, on
the assumption that the CD and the DVDs were the same thing, which they were not.
Right. And she didn't even address that. She didn't even address that at all. She just dismissed that completely. And you notice the state does the same thing. They cherry pick, even though they say that they're not, but they cherry pick things out of the brief that they can argue or they're thinking they can argue, and then they completely ignore other areas.
And like I was saying earlier, the state words their filings as though they are the court making the decisions. Mm-hmm. And I feel like that is a big reason why a lot of the people who are reading these filings, they are under the impression that, Kathleen's request was denied because the state denied it. But the state doesn't get to deny it. It's the court that gets to deny it. And but the state words there, the verbiage they use in their filings as though they are the ones who get to make the decisions.
Right.
And
As a definitive thing.
this was not sufficiently pled.
Right.
You don't get to decide that.
Right.
This is your opinion.
Right.
they-
And that's something that's very important that people recognize. Just because the state may make a good case for themselves,
Right.
Especially when it comes to pleadings. When it comes to insufficient pleadings, that is absolutely for the judge to decide. That is not for the state to decide. When it comes to procedural bar, obviously that's still for the judge to decide, but the state can have a stronger argument with that. But when it comes to sufficient pleadings or not, that is completely up to the judge. That is, so when they say that it's insufficiently pled, which they said about most things, they're just saying that because that's what their position is.
That's what they think.
It doesn't make it true.
Right. And I want to make
Okay.
sure that everybody who's watching this video understands that as you're reading this is not a decision that's been made.
Right.
That's just what the state is claiming. Anyway,
Julie's,
Next question.
Go ahead.
Julie's talking about the tone and style of the brief that at least I think so, that, you know, maybe a contrasting tone or style compared to the way that Zellner's team worded their brief. I don't think, to me, one's more matter of fact than the other, but you know, both sides are arguing this is the standard of review. This is why it meets the standard or it doesn't meet the standard. Or Julie, the way you read it, you think that the state's brief is more direct?
No, I'm going off of what I hear people saying as they read it. Like, I see people tweeting and I see people.
Okay, I get your point. Yeah.
They're saying, oh, the state has denied it, because that's the impression they're under based on tone.
Yeah, people, because they're just not used to it. It's like, I
Yeah.
can't believe, I saw comments the other day, I can't believe the judge would say that. I'm like, no, it's not the judge. It's an attorney that works in Madison, Wisconsin at the Attorney General's office who writes it out. And
All right. We have 10 minutes here, so let's get through these. We have a lot of
Yeah.
questions to get
Okay.
through. So lightning
Yeah.
round. Ready?
okay.
Okay.
This is a really good question from T1. Is the verbiage used in this response normal in the legal profession? And will the courts find the sarcasm and hostility distasteful or disrespectful? Or is this just
T-bone, it's
That's a great
fairly standard. I didn't see anything rude or snipey in this one like there was between Kathleen and the circuit court judge down below. That pretty rare that they were going after each other and kind of firing arrows at each other, but didn't see anything beyond the pale in either brief. So far, Tracie, the question was, is the verbiage in both briefs, is it
in the
out of
response?
the
Is the
ordinary,
verbiage in the response normal? Or will the courts find the sarcasm and hostility distasteful or disrespectful?
They probably won't care. I mean, the court doesn't really have much tolerance for a bunch of BS between lawyers, so they probably won't care much. They probably won't even acknowledge most of it. They're going to rule on the merits of the actual appeal, not necessarily the issues. Now, like, okay, and this is what I said in my last stream, and I want people to be very clear about this. This is not a decision that is going to decide whether Steve is innocent or guilty, or whether his conviction be overturned or not. This is strictly going to be a decision based on whether he deserves a hearing on what has been presented so far. And from that respect, I think he absolutely should have a hearing. He should have had one in the circuit court to begin with. So if they decide that he shouldn't even be granted a hearing, that will be very disheartening, because I can't believe that with everything Casey has presented, that they don't think that he shouldn't at least be given a hearing to further pursue some of these claims. But I just want to be clear on that, so that some people aren't expecting there to be like a conviction overturned when they come up with a decision. This is all about just, should he get a hearing? And I think that, whether KZ has presented enough to win as far as getting the conviction overturned is not the question right now. The question is, has she presented enough to warrant getting a hearing? And so it's very important to make that distinction. I don't even know if I answered your question. I just totally got lost in my own thought there.
No, that was good for me.
This question is from Cherie. I hope I'm pronouncing that right, Cherie. Travis said earlier that we should get the appendix. Does he mean that it can be FOIA'd or that we should compile one ourselves?
We should order it from the clerk of the court. And
if you got lots of money.
And how many pages is that? I'm asking this now. How many pages is it, and how much is it going to cost?
I'll get it. I'll get an estimate.
It's not just
ballpark
or other items. Isn't there like a
boxes
CD?
and boxes, right?
Yeah.
Mm.
What are they charging, Tracie? You've gotten documents from them. Is it a quarter a page or 10 cents a page?
The Court of Appeals is actually cheaper than Manitowoc is, but don't ask me what the price is because it's been a long time since I've gone to the Court of Appeals to buy something. But the per page price is cheaper from the Court of Appeals by like a lot, by like half, I think, compared to what it was something like 10 cents per page from the Court of Appeals, where it's like 20 something from Manitowoc.
We will find out and we will post it.
I'm working with
on Twitter.
Oh, Twitter.
If it's 1,000 pages, so that's going to be $100, right?
Yeah.
More volume.
Next question from Linda K.
The biggest problem with the Court of Appeals is that, like, Manitowoc County, believe it or not, even though Manitowoc County is kind of a smallish county or whatever, you can still email the Court of Clerks, or you can call the Court of Clerks. You can still file, you can send payment electronically and then get an email back of the papers that you want, the documents that you want. For the Court of Appeals, they are a pain in the butt, and that the only way you can get something, at least unless something's changed, is they have no way of electronically processing payment, which means if you want something by mail, that you have to first email them, find out the number of pages it is, and find out the per page price, get the quote from them, and then send them a check in the mail or a money order, I think, in the mail, and then they'll snail mail you the document. The only other way to get it is to actually go to the Court of Appeals, which I've done several times, and trust me, it's a pain in the butt because they want exact change from you. And trying to find a place around the clerk's office that gives change is more difficult than you would think. I went running around for like
This
3
is the
blocks
21st century. Come on.
And have everything.
Yeah. So it's not easy getting things from the Court of Appeals, and
Will you
unfortunately,
be mad if you try to pay them in pennies?
yeah, I totally would do that just because it's so annoying because they're like, we need exact change, and I'm like, are you kidding me right now?
I would pay them in pennies. Anyway, sorry, Fen.
All right. Next question from Linda K. Listening. Where does KZ go from here? What are her next moves?
Well, she has the option to file a reply brief, which she'll file. The reply brief can only address issues that are in this respondent brief. So she can kind of get, yell back at the state about some of the things that were ridiculous to her.
Pause, Tracie. As it says on workwithkz.com, right now, her deadline to file that is June 11th.
Yes, because she has 15 days. So she could ask for an extension, though. 30 days would not be uncommon just because of the fact that Casey is very busy. She has a lot of cases. And so she could take longer than the 15 days. But by statute, she has 15 days, which would be June 11th. That's where that due date comes from.
Okay. Next question from Master Crooner. Does anyone know how many other cases KZ is currently active on? In other words, how much focus is she able to give to Stephen Avery's case?
She has a lot of other cases. Let's just leave it at that.
I get the impression that she does give Steve's case a lot of focus, though. Do you agree with that?
She personally,
not her personally, but her team.
Right. Her team still gives it a lot of attention, and she is still working on leads and things like that. But her personally, she's focused on dealing with the actual briefs and oral arguments and things like that in all of her cases. Mm-hmm. So as far as the legwork goes, she actually, she has a team that does that for her, and they are still very committed to Steve's case. So that's good. And I know there's still things she's working on.
Okay.
Even now.
From Sapper Cop. The defense did not have the information on the CD. the CD had specific search parameters and search findings. And we did touch on this a little bit before. Do you have anything to add about that? The fact that the CD and the DVD were not the same.
Well, they weren't the same, but the defense had been given the document, which was the DCI report, that let them know of the existence of the DVD and the CD. So that means that it is still the defense's job and responsibility to make sure they had that information. It's not up to the state to actually hand over everything. I mean, they gave them the DCI document. It's a little sneaky, and it would be better if the state was responsible for just making sure to hand everything over too. But the defense has to do their due diligence as well. The state is not required to do their job for them.
So they are not required to turn over that, for example, that CD.
They did turn over the CD. It was wasn't it the DVD or I don't know.
They gave them a bunch of DVDs, but they created a new CD based on the research that they did on that computer. And I think the argument was when they got the computer, the actual stuff, it didn't contain everything anymore because when they did their testing, they deleted some things or possibly deleted some things, etc.
And I know there was an issue with them not having the correct software, which is absolutely not a defense at all. I mean, not having the correct software, you find out how to get that software.
The state provided a document to them telling them that they didn't find anything that was of substance or
And again, yes, you can try to look at it from the point of view of the state trying to fool them, but come on, like you cannot absolve the defense of not being a problem. That being
but it's still intentionally misleading.
Right.
There has to be some sort of
and as Henry just said, they said that it was Brendan Dassey's computer.
Right.
And I will personally, as somebody who's studied the law, I will never completely fault the state for that. I think that Jerry and Dean were completely stupid. And I will say it, like point blank, to believe Ken Kratz when he said that there was no evidentiary value on that computer. I'm like, I'm sorry. Like you look at everything when you're dealing with a client that really doesn't have a whole lot going for him and have a whole lot in his defense. You look at everything, and to sit there and take the word of the prosecutor is, to me, is more ineffective assistance of counsel than a Brady violation. That's
definitely. But at the same time, what about the responsibility of the state to ensure that they are being forthcoming with information?
Yeah, right.
The state actually fulfilled its obligation though, because it told them what they had. I mean, and you would think that it means that, well, we should also follow up by just giving it to them. But that's where you get into a gray area, where it's like, I don't see them winning because it's not black and white enough. I don't see Steve winning on that because they're like, well, your lawyers were given the information that said, we have this disc that says exactly this. If the DCI report hadn't been so clear on what was on that CD, it would probably be different. But they were very clear in that DCI report what was on there. And that is a failure of the defense. That's not really necessarily the prosecution's job. In a perfect world, yes, the prosecution would have just handed over everything. But honestly, who's to say that Jerry and Dean still would have taken it seriously? Because, I mean, if they read that DCI report, that should have been enough to know, like, holy cow, this is a big thing. Like, he's searching for, murdered women, and he's searching for, like the things that Bobby was searching for that was in that report. They missed it. Plain and simple. They missed that. Because all of that was in the report.
That's a good support for the IAC claim.
Right. And that's why I didn't understand. I was never quite understanding why she filed it as a Brady claim as opposed to an IAC claim. And I said that right from the beginning. And then when she filed later, she said, well, in the alternative, it could be an IAC claim, but then she provided no support. That is an example of an insufficient pleading. The state is absolutely right when she said in that supplement, when she said, well, in the alternative, if it's not a Brady violation, then it's an IAC violation. She provided no supporting evidence of that. So if you want to see an actual example of an insufficient pleading, that is it. But all the other stuff they're saying is an insufficient pleading does not necessarily qualify. It's just in that one case, they are correct. Because Kathy was like, in the alternative, if it's not a Brady violation, it's probably IAC. Whereas I personally thought the IAC claim was stronger than the Brady claim.
Okay, next question. This one is from Eric Jose. How do you guys feel about the state's argument that they didn't violate statute?
And I said that I don't know exactly what he was talking about. I told him, I said, I think I've read that far.
The subject
Yeah,
is. Eric
no.
Jose, if you're still here, type some clarification in the chat.
What
And
statute did they say they weren't violating?
next
Probably
question.
the preservation of evidence, or probably the
Yeah, probably the preservation statute.
Do you want to answer it as if that's correct, or do we want to wait for Eric Jose to give us some clarification?
I think that's, I mean, and that's something we've talked about before, is just that if they say that it wasn't against statute, that's a he said, she said situation. You know, Kathleen is saying, yes, it was against statute. They're saying it is. I don't expect them to say anything different. And that's for the court to decide.
But they paint some pretty broad strokes about this, that they get into the purpose behind the preservation statute, and they say some pretty broad and sweeping things in light of the no Wisconsin appellate court construing the statute. But things like, you know, as I recall, that that's not the purpose of the statute. It was never intended for agencies to have to retain all biological evidence. Some of their arguments just appeared to be bizarre. So let's talk about something that's right in line with this. Do you see very many amicus briefs filed at the Court of Appeals level? For example, the Wisconsin Innocence Project, Finley, who helped write the evidence preservation statute from the defense side, and after it was passed, went all over the state talking to bar organizations about what the statute was about, why it's a good thing, you need to do if you have a DNA case. Do you see many amicus briefs filed there? Like they would get and say, look, we were around when evidence preservation statute was passed, and we're not taking a position on either side of this, but
No, I mean, violations of the preservation statute has been, I mean, there've been like 2 cases. It's there's the case law is just so minimal on that. This is not an issue that comes up a lot. So that would be
I meant amicus briefs in general. So, I mean, this seems like it would be a good issue for Kathleen to get the National Association of Criminal Defense Lawyers, the Innocence Project, other organizations filing amicus briefs to say, you know, this is the way this has to be construed to give it any effect whatsoever, what the legislature intended. But it may not be the practice in Wisconsin for them to accept amicus brief. I don't know.
Did you explain what an amicus brief is?
It's just a friend of the court. People may recall Eric Jose did a video. There were 5 amicus briefs filed in support of Brendan's petition for cert. Former prosecutors, different groups filed an amicus brief. And it's basically just saying, we're not standing in the position of the defendant or the state. We want to let the court know why our group, why our interest, you should find in a particular way. The short way of saying it is that it helps the court understand what some of the unintended consequences may be of a particular decision.
I'm so uncomfortable. Don't mind me.
Okay, moving on then. Let's get Tracie out of here.
I'm so uncomfortable.
Next question from Henbury. The state's response draws a lot of inferences from KZ's experts, which they didn't necessarily make. Can the state preach like that, or does it need to be resolved with a hearing?
Well, they can say whatever they want. Let's just be clear. Like, they can say whatever they want in a brief. Obviously, that's something you would hope that a hearing would straighten out. Hopefully, it's something that KZ would straighten out in her reply. If they're stating something that's incorrect, hopefully she would call them out on it. But they can say whatever they want. It's just a matter of what they can get away with. So I would hope that they would not get away with stating something that's incorrect.
Okay. Next question from Cherie. I remember Travis said the other night that there is a case or a few cases that provided reasons that might help KZ with the procedural bar due to Steve's first 97406. What factors might help with that?
I mentioned, she cites that 2010 Allen case, it's the three cases she cites, but unfortunately, it's kind of dicta in those cases. And for example, that somebody who's in prison or indigent, why that might be a good reason, but there's no case directly on point. And so that, she's got the statute that says you got to bring it all in unless you have in one motion, unless you have a good reason. And then she doesn't have a lot on her side case-wise that explains what a good reason is, but she's laid out some good arguments as to why she thinks she falls under that exception. You have a different take on that, Tracie?
No, she lays out a lot of good arguments of common sense. A lot of good arguments about logic, common sense, things that most people would think. But she knows as well as anybody. That's not the law, though. When she doesn't have the case law to back it up, it's very hard to win on those issues. Right. And for us, it makes sense to say, well, when somebody doesn't have the money to hire investigators, how can they file a petition that's going to be of help to them, especially compared to a private attorney? That makes perfect sense to us, but the court has yet to actually rule on a case where it says that a pro se petitioner should get another chance at filing a post-conviction petition because of the fact that they're pro se. And I just don't see them ever ever going down that road, because if you start getting case law that kind of gives favor to pro se petitioners, you're really kind of going into a dangerous area as far as post conviction goes. Again, from a legal standpoint, and you always have to look at things from the standpoint of most people being guilty. If you look at it from the point of view that we look at it as Steve being innocent, nothing seems fair. You have to try to look at it also from a standpoint of how most people are guilty.
Not only that, but if they go down the road of saying, well, because they were pro se or because they couldn't afford an attorney and they had to use a public defender or whatever, they weren't able to provide a sufficient defense, then they're going to be in a position where people are going to demand that public defenders and public counsel provide more things that cost more money. I've been drinking, so my vocabulary is about this big. But it's going, because you get a private attorney and you pay them a lot of money, they can pay experts and they can fund all of this stuff. And public defenders don't have those resources. I mean, the prosecution does, the DA's office does. They can spend as much as they fucking want to convict somebody, but not public defenders. And if there's case law saying that, well, because they couldn't afford a private attorney, they couldn't, supply a sufficient defense, then they're going to be in a position where public defenders are going to have to be able to provide those resources, and that's going to cost more money. Right. And the states aren't going to want to put that money out there.
Right. The states want to fund their case, not the defense.
Right. They're going to want to fund the prosecution and not the defense. And I think that probably plays into it also. In addition to what you're saying, at least common sense tells me that has to be part of it.
And there's also the point of saying that when you're talking about very well-established case law, especially within a state. So when you're talking about for Wisconsin with Escalana and Romero, that those are very well-established IEC cases or procedural bar cases. Most states, like I said, once you have that rule in place, it's going to take a lot to change it. Just imagine if now the state of Arizona decided to try to change Miranda. That Miranda is such a huge case that has been cited a million times and has become so much a part of the Fifth Amendment that imagine them trying to now change Miranda. So case law might not be the same as statutory law, but it can still be just really difficult to change those laws. And that's how procedural bar, as far as those cases, has been so well established for so many years that it's going to be really hard to change that. And I don't know what kind of case it would take to change that. I think there need to be more wrongful convictions or something, because again, the biggest thing is them saying that you cannot file more than, one petition. That's it.
So listen to this. He
Question.
cites Rothering and State v. Allen for the proposition that the Wisconsin Supreme Court has gone so far as to note that following Rothering, IAC claims are not barred by Escalona and Arana.
Right. And
So
that's a big part of
that one is good, but we could still lose a lot of other
right.
claims if they stick her to getting past the bar.
Right. And IAC claims have always been kind of their own thing, probably because you can have both the trial attorneys, you can file IAC claims, and both post-conviction and appellate counsel. So IAC has kind of always been handled a little bit differently, because that's different in the respect that you're coming later and saying my lawyer screwed up. It's not just like that something was hidden from them or was kept from them. You're actually saying, now I know I found enough evidence, proof that my lawyers didn't do a good job. So IAC claims actually are a little bit more forgiving with procedural bar than like a Brady claim. But who knows?
Are they more successful when the attorneys who are being accused of IAC cooperate with that claim? As in this case where Jerry and Dean are saying, yeah, sure, I'll sign an affidavit saying, yeah, we did screw up. Does that help?
Well, it doesn't hurt, that's for sure.
Well, but does it help? Does it make a difference?
If I'm being honest, probably not. Because they're going to expect that in general. Lawyers are always going to, lawyers expect to be have
fall on their sword.
Against them. They expect that to happen, especially if they particularly care about the client. They're going to testify, we screwed up, whatever. The court doesn't necessarily always take that into it's kind of like when you have your wife is the one that alibis you out for a crime. It's kind of carries the same weight. It's like, yeah, you have an alibi, but we're not going to carry that with so much weight because these people have a personal interest in how this comes out, how this turns out.
Right. Okay. Sorry. Oh, Fen disappeared. I don't know what there she is.
Oh my God, I've been here forever. This has been the longest live stream ever.
Okay, I didn't hear anything anybody just
for
said.
8 hours before with Allie, remember?
I didn't hear anything anybody said because we've been on so long that my headset ran out of batteries. I had to put my headphones on, which doesn't really work with my crown. So let's move on. I hope you've answered that question well. I'm sure it was great. Next question. Let's go. Neverly Darlin asks, has the family ever asked for the bones to be given back? If so, where is that document?
No, I don't think so. No, that doesn't seem like they have. I don't think the family had much to do with any of that. I think that they probably made a simple request, and that the state didn't even argue with it, and they just gave them whatever. I don't think it was much of a.
So you think the family did ask for the bones back?
Well, I think they would have to, because I don't know why else the state would just give them to them. I think they would have to make a request and say, can we?
I can think of a lot of reasons why they would.
Yeah. But in general, I think I would take it.
But we don't know. We know they got delivered to Whiting Funeral Home, but we don't know what happened to them from there.
Right.
I think
And
didn't we
don't know what
hear that
told.
they did a burial?
I don't know if
That's all
ever-
speculation.
Right. I think that was
In
just
burial.
rumors. I don't know if there's anything that is other than saying they were given to the funeral home. I don't know if anything past that has been proven. It's just been speculation, I think.
No, which goes to the point, she should have got an evidentiary hearing. What were you told about these bones? Who was it that asked about them?
Right.
And then the three stooges who went through the bones with the Eisenberg report and determined what were Teresa and what were not Teresa. I mean, you have to have a hearing on that.
Right. And that's what I always wanted to know. I wanted to know, did Wiegert or Fallon tell them, well, these may not be Teresa's bones, but if you want them, we'll give them to you anyway. Like, was that what they said? Because they're claiming that they were not definitively Teresa's. I'm like, well, did you tell the family that? Or if you told the family these are Teresa's bones, that is very significant from a legal standpoint. That you are representing that these were her bones, which means then you are violating the preservation statute. Oops.
Okay, next question from Master Crooner. Does the panel think that the primary burn site is where the teeth are at? In other words, not yet found? Since the teeth are all missing.
It was somewhere other than behind the garage. That's all
Yeah,
I'm saying.
I would
The
agree with
primary burn site was not behind the garage. That's as much as I can say.
Anybody else have an opinion?
I agree with Tracie.
Mm-hmm.
Okay. Henbury and Julie already asked us, is the color of the RAV4 of the current legal significance? And I think the answer is no.
No.
Sapperkop, if he was procedurally barred, why would the courts have allowed it to get this far?
Well, because anybody can file anything. I mean, you can make the filing, but essentially the court hasn't allowed it because the judge denied it. So, I mean, you can't stop somebody from filing something.
This goes to what we were talking about at the very beginning. So the state kind of prompted her to, get a stay, get it remanded back. Then he files the motion for post-conviction relief, the second one in the summer. And then they send a letter to the judge and say, well, this can't go forward. There's another one pending in the Court of Appeals. So she dismisses that one. And then for 10 months, I think is why they're asking, why would the state work with her for 10 months, agree to testing, do different things, only to have the judge come out of left field and issue this order? And I think it's because the state wasn't anticipating it either. They wouldn't have had a meeting. But what's your thoughts on that, Tracie? Why have a meeting to discuss issues and what items they can test?
I've never really been able to wrap my head around that because I was the one that, I sent it to KZ right away when when I pointed out that Fallon's the one that said in his letter that they would agree to test these items, and yet then later they're saying that they don't have them. I just think that I don't know. I think that the state's just trying to. I don't know. I really can't make heads or tails out of it. That's why I just do not understand how there's no hearing, because there's such conflicting information about it. Because that letter very much implies that they knew they shouldn't have been getting rid of this stuff. And yet obviously in their response to the motion about it, they're saying like, well, we had the right to, and obviously the circuit court judge was going to go in their favor. So I have never been able to make heads or tails out of it. I really don't. I think until we actually get them in a hearing and on the stand, we're never going to really have even any idea at all of what they were thinking. Because how could we? Because I mean, we can say from a standpoint of thinking that they're corrupt, we can just say like, yeah, they want to get rid of any evidence. But in general, I really don't have a clue what they were doing with that.
Okay. Next question is we've got a couple from Henbury here. What is the test for weighing procedure versus merit?
Procedure wins.
In Wisconsin, they're very, very strict. And even though you end up with absurd, unjust results, just take a look at that Henley case. I won't repeat it, the facts again, but all you need to do is read Henley and you see that form over substance is important in Wisconsin.
I think, Henley was a perfect example of a case where it proves that Wisconsin really does not care about fairness or about justice or about the truth. They're all about just keeping people in prison. There's no case that's more clear cut about that than Henley. And that's exactly what they're doing with Steve. That's why I said the brief is sort of like, we're right, you're wrong, and Steve should be in prison. That's like their argument, because what else do they have? And so they're just going to hang their hat on that. And they're hanging their hat on procedure because they have no argument for a lot of the other stuff. The merits, I mean.
All right. Next question is interesting question. What case law was relied on for the first case that was ever tried in court?
Jesus, I don't know. That's a Travis question. Ask an actual lawyer.
Think about the question, Tracie. What case law was relied upon for the first case ever tried in court?
There would be no case law. It'd be the Constitution you're relying on.
Right.
I'm married. Stop it.
Constitution.
I have brain issues. Stop asking questions like that.
So the last question we have is from Graham Moss. The state's response said Ryan Hillegas had an alibi. He was with friends all day, but Ryan Hillegas told the defense that he was not asked for an alibi. So they said he had an alibi, but he said he was never asked for an alibi.
That's another thing we're going to have to dig up. We're going to have to dig that up with see what they rely on that.
That's another situation of he said, she said. The state says one thing, KZ says another, and the court's going to have to sort that out.
Yeah. So the state said with regard to the day planner and Heidel's affidavit that doesn't say exactly what Zellner says it says. And that's a couple of things that we're going to need to get researchers to pull up the actual documents that are being referenced and lay out what it actually says. And it's like with the news these days, you gotta, if you really want to know without the spin, you kind of have to look at the source documents. But this group of,
I'm sorry.
Go ahead, Julie.
But the question was, Ryan on the stand said they never asked me for an alibi. But the state filed a response just now that said Ryan had an alibi.
what's their source document? That's all that matters. They either have a source document or not.
That the state filed.
They may have a source document. I don't know.
But did KZ specifically bring that up in the petition or in the appeal document, in the appellate brief? Did she bring up that, well, they said that Ryan had an alibi when he said in court he didn't? Unless she brought it up, it's not.
They just said it, though. They just said it in their response.
Then it doesn't really matter.
Response. So they
why they would even say that?
Ryan said they never asked him for it. Regardless of what KZ has said, does that matter?
No, it shouldn't, because I don't even know why they said it.
Yeah, it's so if it's I haven't read it, or I don't know exactly where it's at, but the state doesn't put anything in there that's not in context. So they would have said KZ makes for example, KZ makes a big huge deal that he was never asked for an alibi, and goes on and on and on about never asked for an alibi, and that's why he's a legitimate Denny suspect. I'm sure they came back and said, what KZ fails to point out is in this document, he has an alibi.
Yeah, that's a stupid thing to even talk about in an appellate. I mean, honestly, because they're the ones that are saying, from what I have read, that like she's coming up with all these theories and whatever that has nothing to do with anything. So why are they even responding to that? I don't even understand that.
Well, I think what has happened is she is talking about Ryan having the page, right? The day planner page.
Yeah.
And they're saying in their response, he couldn't have had the day planner page because he was with friends all day.
He had the freaking page.
But
No. What they're saying is that Zellner claims and Avery's in her brief, she doesn't quote the affidavit. She avers that the affidavit says Teresa pulled off on the side of the road and we discussed some scheduling things and she wrote in her day planner. What the state is saying is, go look at the affidavit. It doesn't say anything near that. And that's one of the things we have to check out.
That's not what the question is, though. The question
What's
is,
it?
the state's response says Ryan had an alibi and he was with friends all day. The state's response says that. But
So
Ryan told the defense he was not asked for an alibi. So the state put in their response to this brief that Ryan had an alibi, but contrary to that, Ryan said he was never asked for an alibi. So how can the state say he had an alibi when they never asked him?
Listen what the question is. So the question is, at trial, he was asked, do you have an alibi? Were you asked by anyone if you have an alibi? In other words, were you ever a legitimate of an unbiased investigation? Were you ever the focus of an unbiased investigation? For example, did anyone ask you if you had an alibi? No, no one asked me if I had an alibi.
Right.
I don't know what's in the state's brief, what they're talking about. If it says in there that the state says he had an alibi from other source documents, friends said he was here or there, that's mentioned in queso. I don't know. I'm not following what the issue would be.
Right. I'm not understanding why that would even be included unless that was something that Casey brought up. Because remember, their response has to be directly in response to what she claimed in her appellant brief.
Graham, what page is it on?
What?
Graham,
Graham.
we're
I'm
asking
the person who
Graham.
asked the question. I'm asking Graham what page it's on so we can
Well,
look at it and find out what the context is.
I don't understand why any of that would even be brought up unless Casey specifically brought it up, which she could have because I didn't actually read that. So I don't know.
Unless they're just throwing it out there. I mean, and like Travis said earlier, they can say whatever they want to say.
All right.
And you said that too, Tracy, I think.
Yeah.
They can say whatever they want
they
to say.
can't say whatever they want to say.
Well, they can. It's a matter whether it's needed.
You'll get your ass blasted. And there's two cases in Zellner's brief where the states blasted her ass and said she's untruthful.
Right.
That's a big deal.
Right.
And they reference source documents. So they know what's in the documents. And they're saying Zellner plays fast and loose with the record and fast and loose with the truth. These things need to be checked out. I'm telling you that lawyer's a 7-year lawyer's got 20 arguments in front of the Wisconsin Supreme Court. She does not say things lightly.
Mm-hmm.
So these things need to be checked out. You don't just say whatever you want. You'll get your ass blasted. And if it's bad enough, you're going to be in front of the bar.
But that's the thing. They still do that. I mean, they still say and they'll just get their ass blasted.
They don't care. Yeah, we split hairs to the nth degree. But we don't pull it out of our ass and quote something in the record that doesn't exist. We'll spin it like crazy.
Right. That's what I mean. Like you can spin it any way you want. That's what I'm saying. Like you can, I mean, you can't come up with something completely out of left field. But I mean, you can spin things any way you want. You can frame it any way you want, whatever, and it's going to be for the court to sort out. But that just goes along with what we were saying before about how Kathleen, when you read her brief, it sounds like, oh, she's got this, like she's got everything right on point, whatever. But then you read the state's brief and they're like, oh, they've got her like dead to rights on this stuff. It's like whoever's brief you're reading is supposed to sound good for them.
Yeah, you bet.
That doesn't mean that it's actually true or that. Right. I mean, and so that's why I say when I say that they can say whatever they want, you can talk like how the court's going to rule in your favor, but you really don't know what the court's going to do with it.
So here's a 10-second example. This is at the bottom, page 95 of the state's brief, footnote 24. Avery again falsifies the record. The prosecutor did not say the state found, quote, nothing of evidentiary value, period, unquote.
citing the brief, her brief, so that's the averment. He said it found, quote, nothing much of evidentiary value, period, end quote, and then cites probably the letter, 744, that's a document number, page 36. But that's just an example. So we're taking one word, nothing of evidence, the prosecutor did not say nothing of evidentiary value. He said nothing much of evidentiary value. That, case in point, what Tracie was trying to point out. Yeah, they're arguing about one word and what the meaning is.
Mhm.
I want to say thank you to everybody who's been hanging out here with us for 3.5 hours.
We still had a fair amount of people who have been here this whole time.
Thank you. You are awesome.
I'm sick of us at this
And
point.
I want to say thank you to whoever is watching this later too. Thanks for
Yes.
coming back and watching it.
Yes.
It's like, how are we on for 3.5 hours? And I was with you two for 3 hours before this.
We love you, Tracie.
I know.
I'm not sure what this is in reference to. How much difference does that make? What's that in reference to, Erica?
What a difference.
80 more minutes. I'm very slow. 80 more minutes. 80 more minutes. That's about how it feels. We're going to be here all night talking about this, and I still haven't read the damn thing other than 35 pages.
Henbury says 80 more minutes. Sorry.
Mhm.
Hashtag 80 more minutes.
Good night, Marilyn. Thanks for sticking with us for this long.
Good night, Marilyn.
It's not even I'm sick of hearing me. I'm like, I'm going to go to sleep. Don't mind me.
All right. Any closing thoughts from anyone? Oh, we were waiting for Eric Jose to clarify. Type
Read it
faster.
No. There is not much of evidentiary value.
Oh, he was highlighting the word much.
Oh, got it.
Oh,
Thank you.
that
Travis,
means there is some
for
versus
all
there is
the help that you gave us on getting this presentation prepared, and Tracie also for being here with us and helping to explain.
Explain something I haven't.
Oh,
That's a thing that's so pathetic about it.
pleasure.
You actually explain it without reading it, without reading most of it, because I know what they've said, and it's just so bad.
how
Go
do you
ahead.
spell alibi?
How do you spell what?
ALIBI.
B.
ALIBI.
Yeah.
Just alibi.
ALIB.
Is that right?
Yes.
BAI.
It's
Jesus.
on the screen, Travis.
Jesus Christ, I'm like,
ALI.
I'm in the document trying to do a search for
He's doing a
alibi.
document search.
ALIBI.
it's the attorney here.
Totally.
Okay, alibi does not appear anywhere in the state's brief.
Okay.
So I
I don't
can't
think
help
Graham is
them.
still here. I guess we'll have to find an answer later, but
I'm still confused about that whole question.
I think I think it was just a statement of
Tracie has
statements, but that's all over the place. Like
Tracie's been going off screen for more beers.
I know I haven't. I've drank a
Her
lot.
buzz level has never decreased.
I'm
She's
actually
like,
back to my Diet Pepsi now because I actually
oh,
drink a lot.
no, there's rum in
My
that.
husband was bringing me refills.
She's plateaued, and she's
Yeah, my husband was bringing me refills. I drank 3 different things, and I was drinking because I was drinking my cider boys, and I drank Angry Orchard, and I was drinking the Ace pineapple cider. So I was drinking like 3 different ciders.
this wasn't full when I started, by the way. It was
I'm
like,
glad
That should have been. If that was full and that was it, I'd be like, "You go, girl."
no, it wasn't full. It was like here, but I've been drinking
like, you
for
go to the
6
hospital.
hours.
I'm done drinking. My head hurt before, and it hurts now. And I'm
All
sorry.
right. We're going to end this broadcast. Let's
Right.
end the
I
broadcast.
always say it's like
Julie's
Ferris
out of-
Bueller at the
I'm
end.
blurry.
Why are you still here? Go home.
All right. I'm going to end everything here. Thanks, everybody, for joining us. Thanks to Travis and Tracie. Thank you all for being here always, Julie. Let's see if you can get yourself. Hey, that worked. You're back. All right. Thanks, everybody. Thanks for
Thank
joining.
you.
If you have any further questions, feel free to email them all to Travis.
God bless you. Yeah,
You can find him on Facebook. Travis at MAM.
No,
You know how to
it's
find
not
us.
still legal to marry your sister in Arkansas.
Oh my God.
I'm
I
so
don't know
Isn't
much
it?
beyond that.
Oh boy. Okay. Thanks everybody. Good night.
Good night. Thank you.
Bye.